Mediation and Law. Extremely interesting panel ahead, which is dedicated to the matters of investment and uh, resolution of disputes through mediation, but also through other alternative ways of resolution and out-of-court resolution. Why this is important? Yet again, we had heard many times today that the world is shaken due to the wars of the globe, which means destruction, and destruction means restoration, and restoration means investment. And investment means the opportunity to have all kinds of misunderstandings. And knowing about the alternative dispute resolution would be very helpful because investment dispute resolution is extremely relevant not only for Ukraine but for many other countries around the world. So I'm honored to give the floor to the moderator, to Natalia Danilko. She has been the member of Ukrainian Academy of Mediation for many years. Has a PhD in law, where she is founder of the legal firm Danilko and Partners, and she's mediator. And she also does public work. She is a member of the city council, and right now she is also member of the committee on land issues, and she makes a lot of effort to make sure there is agreement in Ukrainian society and in Odessa community. I know how much of work you do and how hectic is your schedule, so it is very nice to understand that you are nearby, that we can count on you, and I can contact you at any moment, and I'm very grateful. So the floor is yours, so that you can announce what we are going to do in the coming hour, what we will be
Доброго дня,
studying.
Луїза. Доброго дня, колеги.
Hello, Luisa. Hello, everyone.
Дякую
First
за
of all, I
таку
would like to
представлену.
thank for such a bright
Звісно,
introduction.
хочу подякувати
And of
за
course, I would like
організацію,
to
чудову
thank you for
організацію цього заходу.
organization of this
Я,
event.
чесно кажучи, сьогодні десь на ранок приблизно
To be
порахувала,
honest,
скільки
I have
телефонів на
calculated how
підготовчу
many raid
робочий
alarms we had
проведення
this
форуму. І
week
я, чесно
during the
кажучи,
whole
нарахувала
forum,
більше
and
40
I have
організейшенів.
counted more than
І
40
щоб
just
було
in
зрозуміло,
Odessa.
це були
So
такі
just to
досить
understand,
жорсткі спроби
those were not
втекти
just raids,
бойових дій. І
those
я до
were
того, що
all
ніщо
serious
нам,
ones,
українцям,
and it means that
вдячна спільноті
nothing
не
would
може
stop
завадити
mediator
провести
community
цей форум.
to
І
have
так, щоб
this
все було
forum,
нового,
to learn
цікавого.
something new, to
І,
learn
звісно,
something
запровадити
interesting,
це в нашу
and of course, we will
практику.
implement it into our practice.
Тема сьогоднішньої нашої
The
спільної
topic of
дискусії
today panel
варта цікава.
discussion
Я думаю, що
is
нам це
extremely
цікаво
interesting, and I
абсолютно
think it would
усім
be interesting for
учасникам
absolutely everyone
сьогоднішнього
who
заходу.
participates
Це
in
екосистема
this
довіри,
event. This is
механізми
the
запобігання
ecosystem of
міжнародним
trust
спорам.
and
Я
mechanism
думаю, що просто
for
сказати, що
sorting
сталий розвиток будь-якої
investment disputes.
держави
And
він
sustainable
неможливий
development
без
of every country
механізму
is not possible
порушень. І
without
сьогодні
effective
зрозуміло вже
mechanism
і
for dispute
дитина, і назва
resolution.
нашої
Even child can
медіаторської
understand it, and not
спільноти
to mention
українців
our
фактично в
mediator
цьому живемо
community,
і
because we
розуміємо
live it and
про
we
надважливість
understand
цієї
the
теми. Але що ми для
importance of
цього
this
маємо сьогодні в
topic.
нашій панельній дискусії
So,
особливо
what do we
мотивувати?
need to pay
В
special
будь-якому
attention
інвестору,
for this
будь-то
discussion?
за кордоном, будь-то
Investor, whether it is
держава
private
приватної
investor, foreign
інвестиції, вважаю
investor,
не лише
they
показники
need
держави,
not only
позитивної
the values of the country or
механізму
economic
і
indicators or
ефективність
development of the
екосистемних
market
тем чи
or
заходів. В
uh,
будь-якому
importance of
інвесторі
this or that field.
надважливо
Each
розуміти, що
investor
він
wants to
заходить в
understand
проект
and
з
know that
певними
they enter
умовами.
in the project with
Яким чином
guarantees.
інвестор
So,
повинен
how
взяти цей
investor
проект?
can be provided with
Звісно,
such
що
guarantees?
один із найважливіших
Of course, one of the most important things is transparency and trust. Each investor needs to understand that when they start project in this or that country, especially in Ukraine, where there is ongoing war and risk is too high, in this context, the mechanisms of alternative dispute resolution become of extreme importance. Every investor is more interested in judicial consideration of the case, and we understand that it is impossible to do business without disagreements. But during the first day of the forum, I was listening to the report by the President's office, who provided numbers regarding how long cases are considered, and we heard about threefold extension of timeline for considering cases in courts. And those are official data published everywhere. If we say that court litigation is 3 times longer now, then we understand that we cannot speak about investment climate trust or anything at such conditions. Therefore, us as mediator community of arbitrators, because we have specialists in various fields, we need to understand that today is the high time to do it and to introduce the alternative mechanism of dispute resolution. And we need to develop them to shape this trust. Today, shaping the trust for investment is like a necklace where we can put pearls on them, and the more pearls we can put on this necklace, the more ecological will be this trust. As Luisa said, in addition to legal practice, I also have political experience. And today, when I represent the country on the international arena, I see interest of international partners in the part of investment into the country. And it is not only about support during war period. It is also investing in Ukraine, which will be after the war. And it will be rebuilding extremely fast. Full-scale rebuild after the war would foresee thousands of building infrastructure and other projects. And all those projects would require stable investment climate and trust we would be talking about today. Therefore, it is with you that we need to shape transparent rules of game. Our discussion would be interesting today. Today, I would be happy to start introducing you our speakers. Those are both Ukrainian, European, Middle East, and representatives of famous international organizations. They have experience, they have also practical experience, and therefore we need to listen to them, take notes, even if we have presentations. Yet it is the experience that we need. Because when we develop all type of matters, it is not only about the stable and reformed legislation, it is also about international experience that we need to learn from. We need to learn on mistakes. And I hope that today's speakers would also tell us about it today. So let's move straight to the discussion. And I would like to introduce our first speaker in our panel discussion. Today is the case where if we are going to name all titles that our speakers have, it will be long enough for the whole panel discussion. So I will be brief. So first, I introduce our first speaker, Mr. Volodymyr Nagnybida. He is deputy of the International Arbitration Court, and we know that this is very efficient institution in the Central and Eastern Europe. He is a professor, has a PhD in law. He is mediator, arbitrator, and a lawyer with over 20 years of experience in resolving cross-border disputes. Hello, Volodymyr. Thank you for joining us today. Volodymyr, today Ukraine, although in a tiny steps, but very confidently goes towards reform of legislation and everything that goes towards creating trust in investment disputes. For example, we have arbitration reform and development of mediation in our country. And in fact, this is a new stage in protecting business. Even now, we have legalized procedure for hearing the international cases. We have liquidated the processes and procedural manipulations that could be. It all raises the level of trust of investors. Please share your experience. Tell us in more detail about your topic from reform to trust, development infrastructure, and solving disputes. Thank you, Natalia. Thank you, dear participants. It's an honor to me to be here today, and I would like to thank the organizers and Louisa and her team who have organized this forum for the 10th time this year. And it is very powerful and interesting event. We see the whole world present here, both among participants and speakers. And it's an honor to be opening this event, especially with such a hot topic, considering the latest changes in Ukraine. And today is a unique panel because publicly, as a representative of the arbitration court, this will be the second time, but in such a group of specialists and among all who would like to practice mediation and arbitration. This is probably the first time we are discussing investment dispute resolution. I mean, after the arbitration reform in Ukraine in April 2026, this is the first time we are sharing experience about what this reform is about. This was one of the moments and why I chose to speak in Ukrainian, because I need to communicate first and foremost to Ukrainian people what happened in Ukraine and how important it was and which opportunities we now have. So, before I start about arbitration, because I represent arbitration institution and this reform and its task was to settle investment disputes. Of course, when we open this panel, we all understand that today mediation I think that mediation is the most important and developing right now. I recall a story back in the middle of 20th century. The New York Convention was adopted on acknowledgement of international decisions. There were not many of them, but it gave a tremendous push for the international arbitration process. And now, a couple of decades passed, and now we have Singapore Convention. And looking at how mediation is getting developed in international dispute resolutions, I hope that Ms. Lea would also be sharing her experience and how mediation is developing in such very difficult and complex category of cases. It is a testimony to the future and a testimony to how effective mediation is. And that there are no other options because mediation is future. It's obvious. Why? I love alternative dispute resolution. I've been here for 20 years, and it is about trust and about flexibility and flexibly approach the format of resolution. But you know, mediation also requires a higher level of trust towards those who supports you in conflict resolution. And when parties are already in this ecosystem of trust and they approach the solution, we understand why the level of execution level and fulfillment is such a high number because we lift the confrontation of parties. And when we settle the international disputes and investment disputes, so of course, mediation is going to be powerful. And maybe that's why arbitration reform in Ukraine that took place is recently and is very fresh. It is of utmost importance. Why? Because it gives us a push to develop market, new push to develop the legal market, to develop the economy, and to involve expertise to develop Ukraine as a hub. And I will be talking about it in more detail during my presentation. So when we are talking about Ukraine as a place to settle investment disputes, and when we are talking about creating trust, we are talking about first and foremost, will be just looking back half a year ago when we were talking about investment disputes as a theory. A couple of years ago, we got an order from the legal practice company. We performed a survey regarding such issues. Do you think that it is reasonable to extend the line of products to investment dispute resolution? And we were using hybrid procedures. So the respondents, as you can see here, are saying that 92% that we need to sort it, and 75% says that yes, we need to expand the services by involving mediation. So we heard and implemented the wishes of the respondents, and in the end of April, we passed the law which expands the so-called internationality of the cases. Those who practice in arbitration, nothing new happened because those rules were already there. For example, USC trial, which foresaw to opportunity to connect international litigation with the place of arbitration or place of execution of
With
obligations.
fulfillment of most of the responsibles. The other thing is that when drafting the Ukrainian law, some of the provisions were now implemented. There was just a part of this paragraph, and this part was somehow missed. Now we're improving, we're filling those gaps, we're aligning them with a transparent, recognizable standards of UCITS right about the international commercial arbitration. And in this part, the law adopted in April this year fills in these gaps. Another very important component it relates to creation the prerequisites for international commercial arbitration. Ukraine it's probably the first time in Ukraine when it determines in its legislation and declared in its legislation that investment disputes can be settled by international commercial arbitration, including located in Ukraine. We know we have many cases when, especially those who practice arbitration, you know that we have this model of dispute resolution in arbitration. When we use ICC regulation, but the location is Singapore, for example. So this model, uh, when the location of arbitration ensures the prompted and easier access to the country, and uh, because the jurisdiction um, and uh, will enable the interrogation of witnesses, collecting evidence, etc., etc. When this investment dispute has the agreement according to the ICCI, UCCI, and others, this jurisdiction is going to review this solution or the agreement. We do have this practice, we do have these examples, and Ukraine now provides for this option to be this place of such dispute resolution. And we do not speak about ICAC, and we have to and something I would like to emphasize on is that, can you see it? That someone drew. So, what I mean, Ukraine moved from the model of participant of investment dispute, and I emphasize that, to the model of Ukraine being the location of considering investment disputes. And these opportunities for all of us who are somehow related to Ukrainian dispute settling market and including mediation and arbitration to shape specific competencies. It also opens opportunity not only for arbitration, but for mediation too, in terms of investment dispute settling. When I speak in front of the students, because I'm a professor at when I speak about the collision regulation and the commercial agreements, I say that international arbitration is like the high-level maths, while there is another direction is that it's relativity theory, because it includes the politics, ethnic issues, um, economy, and property issues. There are so many dimensions, and you have to have the specific legal mindset to be successful in settling those disputes. So Ukraine now has established those foundations. Let me go back to slides back. So Ukraine provides for the fact that commercial arbitrations can settle the disputes, and it provides the location, the participants, and it also provides the procedures that will resolve those disputes. So we have now the position of the state that says, indeed, I acknowledge that when speak about the investment uh, arbitration, they can be applied to the investment disputes. The, uh, the practice shows that what was disputed is the applicability of the commercial arbitration to such disputes. Let's move on. We spoke about the reform and general terms. Now you can see the link. I hope this little line won't prevent you from scanning the QR code. Here you can see the translation of certain amendments, and a participant from abroad. This is um, for you to familiarize yourself with the official translation of such amendments. It is available on the official website of Ukrainian Parliament. What do we have now? So, Ukraine, in fact, said the government supports the infrastructure for arbitration in Ukraine. What do we have for now? Ukraine has at least two arbitration institutions. This is ICAC, this is the Maritime Arbitration Commission with Chamber of Commerce, and we also have the statistics here. During 35 years of existence, you can see the number of international, there is no domestic disputes. This is a number of international disputes considered by ICC and UCCCI of Ukraine. This is about the numbers, this is about the expertise we have. Of course, it is settled by within arbitration who have the wide representation across the world. But of course, it's about the accumulated expertise ICC and UCCI have. When we speak about the terms, it is very important that these disputes were not prolonged in terms of their consideration, because there are so many parties, many parties who are non-signatories. So it is very important that these expert conclusions were regulated, and it's important to have these procedures that have the specific timelines. The ICAC practice shows that there are over 90% of disputes addressed within 6 months. Another important thing is that it's not. It's important the execution of the solution of the decision. So it has to go through the state oversight procedure in the courts. We have these regulations of the New York Convention of 2005 we can refer to, but it's very important that these decisions are legalized. And in 2026, 39 decisions were disputed or appealed. 11 are still under consideration. What is important that in 2025, only 2 decisions, 2 settlements were declined, and it's very important. It's really small statistics. This QR code will lead you to the more specific statistics. I won't focus on too long on the achievements of a CAC, but on one side, we have the legislation. On the other side, we have a certain scope of expertise. And at least in arbitration, it is institutionalized. And during martial law, we have gone through so many challenges, no matter the alarms. But what is important to understand that with adoption of this law, we have the new opportunities for mediation in this area. So their colleagues, their mediators, and those who want to become mediators, the aspired mediators, you have this great chance. If you don't have the certificate of mediator, don't waste any time, but because it's a wonderful perspective, very promising area. We have to understand that investment disputes are very complex, but they have very many accompanying auxiliary components, and they will be settled through mediation. There is some basic dispute. There are its impact, but there are many things around, and I rest assure you that we will have mediators will have more than enough work in this area. And something else I would like to mention. In my humble opinion, for Ukraine to shape the full-fledged market, we have to look at the experience of ADR abroad. And we look at Switzerland, Britain, France, and other countries. And the experience shows that there are the several components are important. First of all, we have to have the updated modern arbitration legislation. We also have to have the set predictable rule of games. The predictability for investor is fundamental because they have to understand what is going to happen 2, 3, 10 years. The alliance with international standards and accessibility of text of legislation in English. We have to have them at least in English, but preferably more than just in English. This is something that we discussed during the forum. Um, Another important component is the judicial support. When the country has the pro-arbitration practice, we have the support of the Supreme Court. Look at please watch the interview with our president. Ukraine has a unique pro-arbitration climate environment. We have the full support of Supreme Court, limited interference, so Ukraine can be proud of that. And it's all about the trust of investors. Third, is the arbitration institution. This is ICC, UCCI are the fundamental centers of that. What is more, we digitalize this area, and here and mediation and investment disputes is very complex because it is associated with case law management, and the human potential here, the talents here are very important component. The should be the case management of very high level. They also have to have a great foreign language command, etc. Thank you very much for your attention. And should you have any questions, um, please feel free to ask them. And to sum it up, all those five aspects, they are core pillars for shaping in this investment jurisdiction. And Ukraine is setting the scene for that now. And it's much is also on us how we're making our choice, how we behave with the clients, how we shape and build the trust, how we cooperate with our colleagues, and step by step, day in and day out, we're going to shape this climate. And I hope you enjoyed this final slide that speaks to itself. Thank you very much. And another thing, that's great honor for me to give the floor to my great friend Matt Hussein, who are going to speak about the mediation and investment. Thank you very much, Volodymyr. Thank you for your very honest presentation, for sharing the statistics. And I have this one question to you, and it's quite philosophic. If we will visualize and imagine that in the system of investment disputes, arbitration and mediation are two living creatures. Arbitration is a grown-up, mature person, even though very young. The mediator is a teenager who is just growing up, and just finding it's a his or her ground. What one advice would you give to this teenager for the future? Thank you very much. That's a great question. Any teenager wants to be heard. He or she can understand things. He or she has some experience, and what they believe is that only this experience is relatable and correct. But when the relations between the teenager and the adult are built up properly, or with all the generation, as someone who accumulated much wide experience, they have this exchange of energies and mutual understanding. I believe that this teenager, if we call mediation like that, is a phenomenon. and we'll maybe speak about mediation in Ukraine in particular. So this interaction can be sourced from our colleagues who are very generous in the experience sharing in other jurisdictions. I'm so happy to see that we have experts from various countries, from various time zones. They're so open to sharing the experience. That's so valuable that this platform brought together people to for experience exchange to promote and develop mediation in Ukraine for the future, and it will develop 100%.
Дякую, пане
Well,
Володимире.
I'm into that.
Пропоную рухатися далі. І
Thank
скажіть, будь
you.
ласка, технічна
Let's move
підтримка має
forward.
підвищитися, мабуть, так?
Is Ahmad here?
Переходимо до нашого наступного
So we're moving
спікера.
forward to our
Пан
next
Емад
speaker.
Хусейн. Пан
This
Емад
is
є
Mr. Imad
незалежним
Hussein.
арбітром,
He's an
тимчасовим
independent
медіатором, старшим
arbitrator.
радником
He's
СІДРА,
accredited
Світового
mediator.
міжнародного
He's the
вирішення спорів,
chief
і є
advisor
заступником
of
голови
SIDRA, and
Міжнародного
he's the
арбітражного
deputy
суду
head of
та
International
Центр організації
Arbitration
громадського
Court for
співвідношення. Пане Імаде,
OICAC.
ми на
Mr.
початку нашої
Imad, at the
панельної
very beginning
дискусії
of our
говорили
panel
про те,
discussion,
що
spoke
розвиток будь-якої
about the
держави,
following. The
будь-якого
development of
законодавства
any legislation of
це
any country
дійсно такий
is
процес в кожній державі.
something
Але
that
без
every country
запозичення
goes through.
іноземного
But
досвіду,
without
а
learning
досвіду
from
великого, який ви
overseas
маєте,
experiences,
будь-яка
especially
держава не
such
може
vast
сформувати
experiences you have,
повноцінно
no
бачення
country can
і
fully shape
критерії
the
певної
vision and
ситуації. І
criteria of
так само
a
це
certain
стосується
situation.
і
Same goes
вирішення
for
інвестиційних спорів.
investment
Тема сьогодні
disputes
у вашої
resolution.
доповіді інвестиційне
Your
посередництво та відновлення
presentation
довіри.
today will look at the
Зв'язку з
investment
інвестиційним
mediation
захистом,
and the
що розвивається.
restoration of
Передаю вам
trust.
слово.
And you will look at the
Поділіться, будь
experience
ласка,
of
вашим
Middle
досвідом.
East for emerging investment destinations. Please, the floor is yours.
Thank you, Natalie. It's really a pleasure to be with all of you today. And I would like to, first of all, to thank Ukrainian Mediation Academy, Louisa, and all my colleagues, my friends, for the great efforts they are doing for such a fabulous event. I would rather call it Mediation Festival and Law because it attracted high distinguished experts from all over the world to share their voice, their choice, and their expertise. I would like also thank my dear friend, Dr. Volodymyr, for such a very insightful presentation, with which is thought-provoking, and it's my pleasure to be here with all of you today. Um, my presentation today actually will be about the trust, how investment mediation and the reconstruction of trust and the lessons we may learn from Middle East, especially from Saudi Arabia and Qatar, where I have experienced it there for more than 2 decades. But before moving forward, I think the word trust, I think we all agree that it's easily to attract investments, but it's too difficult to trigger trust. So it's rather than investing in projects, we are all should think about how to invest in trust. And that's why, just before we start my presentation, and a small island like Singapore, the vision of the judiciary there, trusted judiciary and ready for tomorrow. So the key word that all the stakeholders realize from the judiciary is trust. And that's really very important to think about. That's why Singapore is ranked among the top ranking jurisdictions, although it is just 60 million and started 1965. So it is trust, and that's what we are going to learn in this presentation. We have a navigation, and by the way, I'm now in Alexandria. This is in Egypt, and I'm here for mediation mission related to investment. So, of course, with full confidentiality, I will relate some of the aspects related to what we are going to talk about. Today, we are going to cover that the two sides of investment is trust and investment and trust. They are two sides for the same coin. I'm so pleased that a distinguished speaker from arbitration arena, Dr. Vladimir, to speak about arbitration. But now we will come to know is arbitration is enough, or we should think beyond arbitration. And also we will come to know about the rise of investment mediation, why there is a rise. Then we will take the examples of Saudi Arabia and Qatar from being two emerging jurisdictions, and then the lessons that Ukraine can learn about while I'm sure Ukraine will be having a very promising journey in reconstructing projects and also reconstructing trust. And then I'll come back to the conclusion. Regarding the trust, as we agreed at the beginning, investments are attracted because of trust, but trust can be sustained if there is an efficient dispute resolution mechanism. That's why it's easy to attract, difficult to go for a dispute resolution mechanism. So that is the importance of trust. It is for sustainability rather for attraction. I remember in one of my articles, I keep saying about that investment here and arbitrate there or mediate there, because there is something missing, which is trust. Also, we all know that disputes are inevitable, but the question is what ultimately drive investors in a certain jurisdiction. 10 years ago, we used to say friendly, arbitration-friendly jurisdictions. Now we need to think about how to be a mediation-friendly jurisdiction. That's the question now, because that also trigger trust, as we'll come to explain. And the trust is built through the ecosystem. And the word ecosystem, easy to say, difficult to implement, because it does need the involvement of the stakeholders, the legislation, judiciary, institutions, in-house councils, external councils, the government. That is the ecosystem. And our focus, how to build the trust and how to maintain the trust and how to support the economy. And if we have just a bird's eye view right now, we will find on the top ranking jurisdictions that have been ranked based on Queen Mary surveys or CEDRA surveys from Singapore, they are all investing in the trust. And the responses from the stakeholders, when they have been asked, what is the first factor that motivate you to invest in a certain jurisdictions? Among the top three, trust in judiciary, trust in local courts, trust in the ecosystem. So trust is an iconic if you really want to move forward. You can have the best legislation, you can have the advanced judiciary, you can have the high-tech institutions, but if trust is missing, everything is missing. So, and that is the strength of arbitration, because it is neutral, it is enforceable, it is emerging challenge. And let me take you back to the history in less than 2 minutes. Every single investor 20 or 30 years ago, whenever going to any destinations, the question is whether this country a member of New York Convention or not, whether this country is having a stand-alone national legislation in arbitration or not, whether this country having an independent judiciary or not, and the rest of the questions. Now, this is no longer, it is still existing, but these are the fundamental pillars, the bottom line requirements. Jurisdictions now think how to exceed in order to lead, and how to build in order to proceed further within a competitive economy. And I'm sure all of us know about the matrix and the ease of doing business. They are all about ease of doing business and all about trust. So the emerging challenges now, it is about cost and duration, especially now with the inflation, with the economic situation in so many countries. It's all about cost and duration. One of the challenges here in this mediation case here in Alexandria, there is an infrastructure project, and one of the main concern about the new pricing of the project once it is completed. So it has become a concern now. And that's why mediation is important. When it comes about the importance of mediation, we all know that recently or over the last few years, they adopted mediation rules, they adopted reconciliation rules. The reason for that, there is a realization that when disputes arise, it is not the problem that arise. It is how it will be resolved. It is whether we have an efficient and effective mechanism or not, whether we have a trust in that mechanism or not. That's why, ironically and surprisingly, there are increasing number of mediation and arbitration centers in some jurisdictions, while the increasing number of cases arbitrated and mediated outside these jurisdictions worldwide. So the balance is that the question here is trust, because the investors may not perceive that trust is there, so they invest in the country, but when it comes to dispute resolution, they move to somewhere else where trust is guaranteed, because but the existing of trust is not enough. It is how to protect that trust to ensure the sustainability. So especially in projects like the infrastructure, the energy projects, public-private partnerships, and I'm sure Ukraine in the next few years will have all these projects within the journey of reconstruction. These projects will be the key projects for enhancing the frame and the business environment in Ukraine. So that is the importance of building the trust. And when you build the trust, now the new trend is not only to issue legislation that providing incentives, regulatory framework, protection, insurance. It is not. Now, if you really want to attract, this legislation should provide a background and a platform for investors to settle their disputes by mediation. And now I will move to these the examples about that to make best use of this of this of this presentation. The two examples I have, one example from Saudi Arabia, in which 2024 they already approved a legislation in mediation, and it includes in Article 10 in this legislation that investors and government are, having the ultimate, are authorized to settle their disputes via arbitration, mediation, or reconciliation. So having a governmental entities and going for this mechanism, this is something new, and this is in the legislation of 2024. By comparison, also Qatar having a similar legislation. It is just about 3 weeks ago, in which governmental entities are allowed to negotiate and with the investors in order to reach amicable settlement before resorting to arbitration or to mediation. This is just a few weeks ago. The signal here is that because of relationship, for example, like the situation here in Alexandria, if you have an infrastructure project and this is affected, it has social impact, it has employability impact, it has heritage impact, it has different impacts on the life of the people and the community. You need to find a way to keep the relationship and at the same time find a way forward. Here, the mediation is the answer, because it is not about your legal position and your legality, but rather about sustainability of this relationship and how to find a way forward. That's why mediation is very important component. And previously, the question was to mediate or not to mediate is not the question. Now, to mediate should be the question, because to mediate, you will reserve relations, you will be able to promote your jurisdiction as a mediation-friendly jurisdiction, and because you are part of Singapore Convention, you are promoting mediation, and the investor will feel this word. And again, the example I have been talking about Singapore at the beginning, the first word any a stakeholder visited the Supreme Court or the judiciary in Singapore, the first word, trusted judiciary. So the word trust, that's why if you visit the the international reports about doing business or rule of law, combativeness, and other international reports, we will find that Singapore among the top 3 or the top 5 jurisdictions, although it is small, although its economy is not large as other organizations, but the key word here is the trust. And also, if we review the reports issued by Queen Mary Surveys 2025 and the previous surveys and currently CIDRA survey, we will have this answer. What I would like to share with you, and this is something not yet published, but I'm so pleased to share with you. Recently, we launched a survey about the Middle East across 22 countries to ask 4 categories: in-house counsels, external counsels, dispute resolution users, and executives. What are your preference mechanism for dispute resolution and the reason for going for such mechanism? So far, it's almost more than 70% of almost 340 responses so far. They prefer mediation, and the first factor for triggering their attention for mediation, if there is enforceability for settlement agreements, and if there is a trust in the system of the jurisdiction, so they will go for mediation, because mediation is almost 20% cost of the arbitration, and mediation, it keeps relations, and mediation, you have the agility. It is like you have a portrait and you have the ultimate freedom to go for the green color or the dark current or the light current. So it is something you customize, you build according to the needs, and you keep it. Of course, mediation cannot be the first the result for everything, but at least to try it. And I still remember in so many meetings in Singapore within judiciary, in every single meeting, the first point, we are not here to litigate, but we are here to find a way forward to maintain relations, and litigate to be the last resort. And as far as I remember, also in Hong Kong now, they are considering a plan that by 2030, all the ADRs, reconciliation, mediation, early dismissal, and all these mechanisms to be the default, and litigation to be just 20% of the cases, simply because they economically, politically, they found that investing in ADR and mediation is worthy investment. The last point, to not take more time now, what lessons we can take away for Ukraine in its promising journey. I think we need to think about how to avoid the dispute, how to invest in dispute avoidance. And I would like to really thank the Ukrainian Mediation Academy in its advocacy and its efforts in doing a great work across the country in spreading with the students, with the, civil society, to make sure that mediation is no longer the poor cousin, but it has become also a rich cousin that we have to look into. So it is how to prevent, how to educate the people that mediation is life, mediation is worthy, and mediation has come to stay. The second lesson, I think, mediation and arbitration, they complement each other. For example, in Singapore, in November 2014, we have signed a collaboration between Singapore International Mediation Center and Singapore International Arbitration Center. It's almost more than 12 years now. Hundreds of cases have been solved because it is just one entry, one destination, and multi-doors justice. So in Ukraine, we may rethink about the ecosystem to have the Ukrainian multi-door justice, in which all the stakeholders working together for one destination, which is the sustainability of the dispute resolution. And I think we need, as just highlighted by my dear friend, Dr. Vladimir, to rethink about the legislation and to publish such cases, and to ensure that we are all in the same page in providing not only an attractive investment regime or system, but rather together with highly effective and efficient dispute resolution. So it's all about the protection. It's all about a strong ecosystem and linking your vision with what you are doing. And that's what the top ranking jurisdictions are doing. I would like to thank you for such a great time. And I'm so pleased that I'm having here the Mediterranean Sea on my right hand here in Alexandria, and also talking to you. That's a pleasure and an honor. And I do apologize if I've taken more time. And thanks a lot for you.
Дякую, пане Імаде, за вашу доповідь, за вашу презентацію.
Thank you, Mr. Amada, for your report and presentation. Thank you very much for your optimistic prognosis for development of mediation in Ukraine and regarding reconstruction in post-war period overall. Thank you very much. So while listening to your report, I have pointed out a couple of issues in the Middle East countries which could also ruin trust. You said that it is easy to involve but difficult to keep, and also cost and duration. And I breathed out a breath of relief because Ukraine also has these issues. And if Middle East countries manage, then we also have no choice but to manage. Thank you very much.
Thank you.
Я пропоную рухатися далі. Надаю слово нашому
I
наступному.
suggest to move forward, and I'm giving the floor to our next speaker, to Oleg Shoko, who is practice in Kennedy's in London, which is one of the leading firms in the Great Britain. He is a lawyer in Ukraine and also represents Association of Ukrainian Lawyers in Britain. Your experience is very interesting because you can compare and combine legislation of the Great Britain and the Ukraine, so you can do a comparative analysis. And please tell about your topic of the arbitration forums on mediation. Of course, on the role, we would not argue. We understand the international forums, they play a key role in transformation of investment mediation and basically turn it from negotiations into structured procedure for dispute resolution, and it is important. Recently, in arbitration and mediation practice was affected by digitalization because during pandemic and now during the martial law in Ukraine, this topic is very relevant right now. Please switch on microphone for Oleg.
Алло, пане
Є.
Наталю.
Чутно. Так, вас чутно. Дякую.
Дуже дякую. Ну, по-перше, дуже дякую за можливість
First of all, thank you
презентувати
very much for
комерційну
this
сторону і
opportunity to
комерційне
present
бачення
the commercial vision, commercial side
медіації в арбітражному
of
процесі. Але
mediation
мушу
in
сказати
arbitration
і
process.
визнати
But
об'єктивний факт.
as a side note, I have to say
Пан
this.
Володимир і пан
Mr.
Емад
Volodymyr and
покрили
Mr. Ahmad
настільки багато і настільки
covered
релевантно
so much and they presented
тематику, що
so
дуже
much
важко,
relevant
в принципі, доповнити
information that it's very difficult to add something there.
загальну думку, але ви, очевидно, праві, що з точки зору,
But
що у мене є
you're right
певний
that I have
ракурс, з
certain
якого я бачу
perspective.
медіацію, як
I'm
доповнення
looking at mediation and I see it as
арбітражного
a
процесу і
addition
способу
to the
вирішення спору,
arbitration
а саме
process
в такій
and
комплексній сфері
in this
судочинства, як інвестиційні спори.
complex area as investment
Окрім того,
disputes.
що я є головою арбітражної
Besides,
практики в
I'm
Canada's UK,
the head of the arbitration
ми
practice in
окремо
Canada's
ще
UK.
займаємося
We also
ініціативою, яка називається «Спілка». Це юридична
focus on
ініціатива
Spilka
в Великобританії.
initiative. This
Мушу
is the
сказати,
legal
що
initiative in
саме через
Great
спілку
Britain.
моя
And I
колега
would like to say
Наталя
that
Гнізділова
through this Spilka
запросила мене на цю
project,
панель, тому я
my
їй вам
colleague
і їй дуже
Ms.
вдячний.
Gnizdilova
І
invited me
через
to this
спілку
panel,
ми
for
маємо
which I'm
можливість
truly
бачити
grateful. Through Spilka
релевантні
project, we can see
запити
the
щодо
relevant
України, щодо місця України в
inquiries, the
арбітражних
needs of Ukraine,
асоціаціях, в
regarding the
арбітражних процесах,
mission of
спорах,
Ukraine in
статистику по
arbitration and
Україні з
disputes.
приводу
We can see the
виконання, з приводу
statistics on
вирішення
Ukraine
спорів
regarding the
шляхом медіації. І я мушу сказати, що я дійсно під
execution,
враженням від
regarding the
статистику, яку дав
solution
пан
and the
Володимир, перший
resolution
доповідач
through
на цій панелі.
mediation
Дійсно,
and And I'm
прогрес
really
країни
impressed by the progress of
очевидно
Ukraine.
помітний,
It
і
is
він помітний не
undeniable,
тільки для
and it
України
is
всередині
apparent
України,
not
так і
only
поза
inside of
України в
Ukraine, but also
відносинах
outside of Ukraine.
вирішення спорів в цілому
When
шляхом
we
арбітражних проваджень,
look
і
at
окремо відносно
dispute resolution
медіації
through
і довіри
arbitration
до
and
юрисдикції України,
mediation and the trust to the
що
jurisdiction,
такий спор
to
може
Ukraine as jurisdiction. There
вирішитися
is
по
trust
медіації.
that
Тому це
this
саме те, що пан Емад
dispute can be
наводив
resolved
приклад
through
як
mediation.
позитивний досвід
Ahmad
на Близькому
presented this
Сході.
positive experience
І
of Middle East,
я думаю, що Україна має
and
всі
I believe
шанси
that Ukraine has every chance
цей
to
досвід повторити або
replicate this
перевершити.
experience or even
Тому
excel
я
and
пропоную
go
сфокусуватися
better
зараз
than that.
і сфокусувати
So my
увагу
suggestion
аудиторії
is to
на
focus
дуже об'єктивні складові
on
медіаційного
very objective
простору. Це
components of
якраз
this
правила, за
dimension. This
якими
is
ми
the
ведемо
rules
переговори в рамках медіації,
we
і як ми,
use to
арбітражні
negotiate within mediation.
юристи
And
і
we, as
арбітри,
arbitration
бачимо медіацію
lawyers
і
and
роль
the
медіації в арбітражних спорах
arbitrators,
саме
and
по інвестиціях.
we
Тому
and
що
what
інвестиційні спори,
mediation role what role the
очевидно,
mediation we believe
мають більш
plays
комплексний
in these
характер і
disputes. As
мають
it was said, they have very
геополітичне забарвлення
complex
дуже часто. Тому
nature, and
медіація
not
достатньо
so
нюансний
very often
тонкий
time
процес
they
в цих
have
спорах, і я
geopolitical
думаю, що має
touch. So mediation plays
особливе місце,
a very important
відкажемо,
role in these disputes,
просторі
and
для
it takes a
саме
special
комерційних
place
практиків,
for
ким
commercial
я являюсь
practices,
на сьогоднішній день.
practitioners
Тому
who I am.
я думаю, що перше, що варто сказати,
The first
що
thing that
традиційно
we
міжнародні
must
спори
mention is
асоціюються
that
саме з
traditionally
арбітражними
investment disputes are strongly
інституціями.
associated with
Тобто тут ми
arbitration
маємо таких
institutions.
аж дві,
Here we have
ІСІД або
two of
юнсітрал.
them. This is UNCITRAL and
Зараз ми бачимо
EC.
тенденцію, що комерційні
Now we
арбітражні
can
форуми
see
теж
that the
починають брати
commercial arbitration
інвестиційні спори
forums
більш активно. От для
step
чого брала
in, and
зараз
they
початково ця тенденція з переслідуванців в
become
Парижі за ICC,
increasingly
що ми
active.
бачимо
We can
також
see the active role plays the ICC in Paris. We can see intensification of ICL. This is our domestic forum. We can also see the upward trend in Stockholm.
Зазвичай
As you may
інвестиційний
know,
спор ми розуміємо
investment disputes are
визначені
usually
держава проти
seen
інвестора.
as the
Тобто
state
є держава,
versus
є інвестори,
investor. We
і
have the
вони
states and we have
часто
investors,
шукають
and
саме
not
не
so rarely
юридичну
they
перемогу в
do
спорі,
not
а
seek
саме
this legal victory in the dispute, but rather politically acceptable or commercially
в якості
relevant.
результату або в якості перемоги
And as a
в
result, as
спорі.
the victory in
Медіація
this
взагалі,
dispute.
мабуть, така сфера
Mediation
вирішення спору, коли
is
саме
the
перемога
area of
не є
dispute
доцільним
resolution
терміном.
is when
І це
victory is
перше,
not
що я хотів
even
би сказати,
an
коли ми
applicable
говоримо
term
про
here.
вирішення
And
спору
when we speak
і про
about
результат
dispute
спору з точки
resolution
зору
and the result
комерційного
of that,
адвоката,
in terms of the
відносини
commercial
між комерційним адвокатом та
attorney,
клієнтом переходять в іншу площину.
we have a different dimension
Тому
of
що для
relations between the
клієнта
commercial
важливо
attorney
отримати
and the
комерційно
client.
доцільне рішення, яке
Client
може
want to
не
get
до
this
кінця
commercially relevant
визначено або
resolution,
визначається
and
комерційними юристами як перемога.
it's not
Тому
necessarily
перша, я думаю,
determined
така
defined by the commercial
перший
lawyers
суттєвий
as
фактор,
victory. So
який
the first
аудиторія має
important
розуміти,
factor
коли
that the
говорить
audience
про
has to
медіацію
understand
як
when we
частину
speak about
арбітражного
mediation
провадження,
as a part
що
of arbitration
client
proceedings
management,
is
або
that
там
client
робота з
management,
клієнтом
or
це найперше,
is the first
що
and foremost
комерційний адвокат має зробити, це
that
попрацювати з клієнтом і
the
довести на
commercial
рівні
lawyer has
внутрішнього
to
розуміння,
do. They
що
have to
медіація
communicate at the
може
level of
досягти
internal
результату,
understanding that mediation can
який
achieve the
буде
result
доцільним
that
або
will be
прийнятним
relevant or
для вашого клієнта. Це ще до того, як ви
acceptable
почали
for your
медіацію.
client. That's all
І
even
це
before
якби
you
і
start the
можливість для
mediation.
вас, і
This
виклик
it
одночасно.
and this
Тому
opportunity that comes with a
якби це
package
чисто практичний
that
поінт,
also has
який
the
ми
challenge. This is a
маємо
very
мати на
practical
увазі.
point that we have to keep in mind.
Є очевидні фактори або
There are
чинники, як
apparent
комерційний адвокат
factors.
подає медіацію як
This is
правильний шлях
how
вирішення цього спору,
this
або більш
that
доцільний
mediation
шлях. По-перше, дозволяє
is the most
відносини між
relevant
державою та клієнтом, очевидно.
way to take. It helps preserve the relations between the client and the state. And when we speak about client, this is investor, because most of all we represent investors, but some of our colleagues represent the state. So it's very important for the state to preserve and improve its investment climate. So if there is a chance to avoid arbitration proceedings, giving opting for mediation, that's a good way. A mediation is confidential by default, but investment disputes usually quite widely covered through media and other ways. So mediation. So the factor number one is here is that mediation is commercially relevant. The second factor is that you mitigate the public attention to the problems or that triggered this dispute. It's favorable for the state that accepts the investor. I believe you know the statistics that the better share of the dispute is when the country changes its policies or it makes some violations actually. On the other hand, when the investor sees that their investments is under the risk in this specific state, it often means that the investor hasn't assessed the risks when entering the country. So there is the question whether it's a public company, not public, whether they performed in a good way, the proper way. There's quality assurance and other assurance. And mediation makes it possible not to present, not to expose all these factors before public. You know, all other factors because mediation cuts the cost and terms of dispute resolution. What's important for Ukraine, especially in under today's conditions, when we have certain commitments, long-term commitments, and there could be certain violations. Mediation makes it possible to restructure investment projects and to implement them step by step from within certain timeline. It's not always possible when you go to court, because court hearings is the fixation, the highlighting the failure to perform certain commitments by a party. Restructurization doesn't fall within the scope of solution of resolving this dispute. Meanwhile, when we speak about the mediation, that's a voluntary wish of both parties. So that's about the tax holidays, that's about achieving some commercial steps that are favorable for both parties. So if the parties are interested in continuation of this investment relations, mediation is the best option here. I also have to mention insurance. Kennedy's, as the firm that specializes on insurance disputes, can increasingly see the contracts that have these arbitration clauses, and they show the mediation as the mandatory way to resolve the disputes within arbitration. Arbitration is not step one when resolving the disputes. UNCITRAL and all other UNCITRAL-based rules say that the parties will do their best to resolve the disputes before arbitration proceeding
контрактно
takes place or
тільки
is
зараз ми
initiated
бачимо там за
by in
останні там
contractual
5 років,
terms, this
коли там 3 навіть,
we can see this
коли
emerging
медіація чітко
trend
записана як
within
стадія
the
процесу.
latest 3 years when
І
mediation is
відповідно вона
outlined at
може
the
бути
stage
вписана
of the
як cooling
process.
off period,
It
може
can be
бути прописана як frustration,
introduced
різні там
as
є
a
варіанти, там по
frustration
англійському праву,
and
не по англійському, але
and
основна ідея така, що
there are
медіація це
various
стадія вже
options in
процесу. А це означає, що пункт
defining
І,
it.
особливо
But what is
в
important
складних
is that
юрисдикціях,
mediation is
до
outlined at
яких,
this
на жаль,
stage.
зараз
Uh,
відноситься Україна, з точки
when we
зору
speak
там
about
військового
these
кризису,
difficult,
політичних
these
ризиків і так
risky
далі,
jurisdictions, including
ми
Ukraine,
бачимо, що є повне
unfortunately,
розуміння того, що якщо ми
for
на
apparent
тесті
reasons, we can
інвестиційного
see
характеру,
the full
то
understanding of the
доцільно
following
було
fact.
б
We have
почати з
this
медіації.
investment dispute.
І тут, мабуть,
It's
слід
appropriate
сказати,
and it's
на
make total
яких же
sense to
принципах
start with mediation.
проводиться
So
медіація загалом
it is
по
important to
інвестиційним
speak at
спорам. Я
the
впевнений, що
principles of
більшість
mediation for
нашої аудиторії
investment disputes.
точно
I'm
знає, на яких
absolutely sure
принципах є
that our
основні
audience
документи. Пан Володимир
knows the
теж
fundamental
згадав
documents, and Mr.
конвенцію
Volodymyr referred to the
Сінгапурську. Але
convention,
давайте, щоб ми були на
Singapore
одній сторінці,
Convention.
як же
But
ми
let
проводимо
us to make sure we're on the
медіацію,
same
які у
page,
нас
how
документи
we
це
carry
регулюють.
out
Тобто у нас є, в принципі,
mediation
три
and what
основних документи,
documents
тобто є
govern
ті,
them.
які ми думаємо,
We have three
в першу
fundamental
чергу, про які ми
documents for
думаємо
that
в першу чергу,
purpose.
коли ми говоримо
We
про медіацію
keep
в
in mind when we
спорах.
speak
Це
about the mediation and investment disputes.
найбільш значуще,
The
мабуть,
most
це право
relevant of
медіації
them is
JCS.
the UCIT
Значить, в
mediation
2022
rules.
році
In
ІСІД вперше
2022,
запропонував окремий
ECIT
комплекс правил медіації,
introduced the dedicated
який
rule set for
може застосовуватися
mediation.
навіть коли
It
спір
can
не
be
підпадає
applied
під
even
юрисдикцію ІСІД,
when
але він загально
the
прийнятий,
dispute does not
особливо
fall
на
within ECIT
суверенному
jurisdiction,
рівні, коли
but
є
it is
залучені
generally
держави.
accepted at the sovereign level when the
Про всі
state
особливості я
is
говорити не
engaged.
буду, тому
I
що це
won't speak
займе в нас,
about
мабуть,
all the
годину.
features.
Але
It will take
загалом
an hour.
ці
But overall,
основні особливості дуже
the key
співпадають
distinguishing
із правом
features
медіації в ІСІТРАН.
ally with the
В принципі,
mediation
вони
rules of
суміжні,
ICIT-RAN.
і
They
основні принципи там
echo one
добровільність,
another, and the
участі сторони,
fundamental
нейтральність
principles
медіатора,
are the
конфіденційність процесу,
impartiality,
гнучкість
confidentiality,
процедури. Я думаю, те саме можна
voluntary
сказати про
nation,
ІНЦИТРАЛ,
and
який більш може
flexibility
трохи
of the
технічно, краще
procedure.
прописано і більш
INCITRAL
захисне,
may
але
go more technical on that,
загалом засади такі самі.
but the fundamentals are
Потім,
still
якщо ми
the
говоримо про
same.
другу основну конвенцію,
The
правило, основні
second
правила, це ІНЦИТРАЛ.
fundamental document
Те саме,
is
що і
UNCITRAL.
в ІСІД правилах, вони створюють універсальну процедуру
Same as in
для
the SIT
транскордонних
rules,
спорів.
they create the universal procedure for
І ж, до
transport
речі, тут можуть
disputes.
бути навіть
And
приватні
here,
інвестори, не обов'язково
we can
державні,
look
тобто
at
вони
not
можуть просто
necessarily
як
at the
за
state investors, but also private
застереженням прийняти
investor,
правила
as
ІНЦИТРАЛ і між собою
they can
застосовувати ці
accept
правила. Навіть
UCITRAL
коли
rules and
є
they
одразу
can
спор, про
apply
спор,
them.
ІНЦИТРАЛ правила можуть застосовуватися
You
навіть
and
між
they can
правилами
apply them
арбітражного ІНЦИТРАЛ.
along with
Ну і, в
arbitration
принципі, і
rules.
засади ті самі, конфіденційність,
Same
незалежність медіатора
same
і
rules, the
самостійне
impartiality
здійснення
of
процедури
mediate,
сторонами,
independence of
тобто повна
mediate,
свобода
the
переговорів,
complete
є всі.
freedom of negotiations
І
and
третє, мабуть,
procedures and a
найважливіше з
voluntary
останніх
mode. And the third, and probably
у
one
нас Сінгапурська
of the most
конвенція,
important, is the
вона не
Singapore
регулює, що важливо,
Convention.
вона не
What
регулює
is
сам
important, it
процес
doesn't
медіації,
govern
як
the
правило, але
mediation process
забезпечує
as a rule,
міжнародне
and yet it
визнання та
ensures the
виконання угод,
international
досягнутих
recognition
за
and
результатами медіації в кінці конвенції.
implementation of the
Дуже подібне до
settlements reached
Нью-Йоркської конвенції, яка
through
подібним чином
mediation.
застосовується
It
для
echoes New
арбітріжу,
York Convention that
що сторони
applies the same
підписанти
for the
визнають, що
arbitration
рішення в рамках
settlements, that
Сінгапурської
the
конвенції,
parties, the
досягнуті між
signatories,
сторонами, мають
recognize
визнаватися на
that
локальному рівні шляхом там
the
певної дуже
decisions
простої
made shall be
процедури
recognized at the
виконання. І це,
domestic level through very
в принципі,
simple
легітимізує і
implementation procedure. It
вбудовує результат
legitimizes
медіації
and
сторін
embeds
в
the results of
загальний контекст там
mediation in
судочинства
the
в певній
general
країні
context
або там
of
в певній
legislation
юрисдикції, в
in a
території
certain
тієї юрисдикції і так
jurisdiction,
далі.
territory, or a
І я хочу
country.
сказати з точки зору англійського
And
адвоката, мабуть,
speaking,
більше, хто
speaking
приєднувався
as
в
the
Україну.
English
І
attorney,
ще раз позитивний сигнал до презентації
and
Володимира,
like
що
to echo Volodymyr's presentation. When we speak about delivery and execution, has long been the barrier in the development of international mediation. Mediation has existed for thousands of years, and it roots from Middle East, by the way. But when we speak at the state level, when there is the dispute between the sovereign and the private investor, mediation rules did not always were not always seen as the reliable tool to make sure that the decisions will be implemented. Today, we can see the increase in trust into the implementation of the results of mediation. We can distinguish the specific stages of mediation. This is three stages. This is mediation, mediation, and commitments and responsibilities regarding the negotiations. This distinguishing these stages shows that the process of mediation is getting more complex, and parties take take it more seriously. So the key task for all the jurisdictions where mediation ensures the stable work and implementation of the results of mediation is to support, to nourish this trust into the process of mediation. And the last thing I would like to say, as a commercial attorney, commercial barrister in England, that the best investment dispute is not the one that was won in the arbitration after 5 years. It's the one that was settled through mediation during 5 months. That could be counterproducing in terms of billing for the legal within the law firm. But when you look from the client's perspective, that's absolutely relevant way. And I'm so happy that Ukraine is progressing on this way. And on the basis of this UK-Ukraine Legal Forum, where have the honor to take part in, we're going to raise the issue of mediation as a part of dispute resolution, especially in the context of Ukraine's accession to EU. And another dimension will be the recovery of Ukraine, because Ukraine is anticipating and Ukraine is going to see the major, huge recovery, and mediation is going to be in the focus, especially in the insurance dimension. Thank you very much, Oleg, and thank you for your very practical points. And I really like that you focused your attention on the fact that we have to start working with the client before the procedure. It's very important. Using paraphrasing a mediation and is indicated here that the individual is above all. It was very important to hear from you that it's important to assess the problem that triggered this dispute. And someone who is engaged in politics, I believe that the state has to carry out this analysis to prevent such disputes in the future. Thank you very much. And let's move forward. I am giving the floor to our next speaker. That's Ms. Fidan Alieva. Are you with us, Ms. Fidan?
Yes, I'm here. Thank you, Natalia. Hope I'm audible. Good day, dear colleagues, dear Luisa, and all the team members, my fellow speakers. It's my pleasure and honor to join this distinguished panel. And I'm going, first of all, I'm so happy to hear, it's like music for my ears to hear that so many colleagues from around the world support mediation in investment dispute resolution. I'm on mediation side. I'm not against arbitration, but I'm on mediation side. My academic research on reconsidering investor-state dispute resolution practices in Central Asian region within my master studies at the Geneva Graduate Institute, together with my experience in commercial and cross-border mediation, has shown me that quite often parties need more than simply legal determination. They need a process that helps them manage risks and or restore and preserve working relationships. Just imagine an investment dispute with hundreds of millions at stake. On one side, there is a sovereign state which is accountable to its citizens and political institutions. On the other side stands a foreign investor seeking protection for its investment. Traditionally, they may enter a courtroom-like battle that may last for years. Even arbitration may take, according to the statistics, up to 19 years. But they may also choose mediation as a dispute resolution mechanism. And today I'm going to, let me share my screen. I'm going to examine the question whether mediation can become a trusted mechanism for resolving investment disputes. From my perspective, there are 4 key pillars of trust when we talk about investment dispute resolution. These are experience, applicability, mediator, independence, and enforceability. So in my presentation, I'm going to briefly touch on all these 4 pillars. First of all, trust is a prerequisite for any investment project. Maybe I will somehow echo my colleagues in their presentation. So if there is trust, investor invests. Investor invests if they trust the system. At the same time, there is another stakeholder, state, and the state needs trust that their right to regulate will be respected. And in this regard, effective dispute resolution should preserve and restore trust, not just simply decide winners and losers. And when we talk about losing in dispute resolution, mediation is the only dispute resolution mechanism which ensures that even if parties do not settle within mediation, either party loses. What does trust mean? What does trust mean in investor-state mediation? Trust is about confidence in the mediation process itself, confidence in the neutrality of mediator, trust that the outcomes will be respected and that the parties' interests will be addressed. When we talk about one of the key pillars, applicability, mediation is applicable to many investment disputes. And it is applicable because it helps to preserve long-term relationships, and for huge investment projects, it's very important. It also allows parties to allows parties to come up with creative solutions beyond monetary compensation. So sometimes, if mediation is used in investment projects, investment disputes, it helps parties to come up not simply with a mutually acceptable, but even mutually beneficial outcome when they benefit from the mediation outcome even more than they benefited from their previous cooperation. Also, in mediation, the main focus is placed on parties' interests. Parties' positions are not ignored, but still the main focus is on their interests. And in investment disputes, there is a range of different interests, including political, commercial, reputational, and mediation addresses all those interests simultaneously. And also, as in any other mediation, in any other field, investment mediation maintains confidentiality when appropriate. As for investment dispute resolution and investment projects, given their public nature, not every, let's say, the investment mediation itself cannot be fully confidential. So flexibility of mediation allows parties to agree what should remain confidential after mediation, and what should be shared with the public. As for enforceability, historically it was a concern. It was a concern until 2019. In 2019, as you all know, the Singapore Convention on Mediation was adopted. Also, there is an ICSID convention. Hopefully, our colleague from ICSID will share more about this convention. So the convention itself strengthens confidence in mediated settlement agreement, and it also signals international recognition of mediation as a serious cross-border mechanism. But there is a limitation. Its enforcement mechanism is available and applicable only in states where the convention is adopted. But I would like to mention two more points in regard to enforceability. The unique contribution of the Singapore Convention is that its effectiveness is measured not by how often it is used for enforcement, but by how its existence encourages and stimulates parties to comply voluntarily with mediated settlement agreements. And another thing that we should keep in mind when we talk about enforceability is that we should rely on international practices. And statistics indicate that over 80% of mediated settlement agreements are complied with voluntarily. So why does this happen? Parties are willing to honor the agreement that reflects their interests and commitments because they actively participate in designing the solution. They often have the strongest sense of ownership, and as an outcome, there is a greater incentive to implement this agreement. So anyway, the enforcement concern can be addressed at present moment. What about experience? Due to confidential nature of mediation process, yes, there are cases that have been mediated, but we do not have enough information to discuss and consider them in detail, but there are cases. It is limited, but there is experience. Also, there is lack of trained government officials and institutional knowledge on investment mediation. But there is a positive side, growing number of mediation initiatives and pilot projects. And also, since I'm representing Central Asian countries, I would say that in our countries, as you can see from the table, some countries has already adopted a new investment legislation according to which there is mandatory pretrial negotiation required, and in such countries as Kyrgyz Republic and Uzbekistan, mediation is formalized as mandatory first step for investment disputes. And another pillar which I mentioned at the outset of my presentation is mediator independence. Of course, when we talk about mediation, we keep in mind neutrality of a mediator and neutrality and impartiality. These are the principles which are being discussed more often, but the independence is something that discussed rarely. And from my perspective, in huge, complex, cross-border international investment disputes, mediator independence is of utmost importance. Of course, it includes independence from the parties and the dispute, impartiality of the mediator throughout the process, timely disclosure of actual and potential conflicts of interest, if there are any. Another point is ability of the mediator to manage cultural, cross-cultural, cross-border political sensitivities and differences without bias, since these are the cases with multicultural or cross-cultural elements. And one more important, that I would mention here is balance between the standards and independence. What we can see and observe in our field now, what is happening is that sometimes our field is getting over standardized. Standardization itself does not impact mediator independence, but it may impact mediators' flexibility and ability to adapt and design the process to the dispute nature and to the parties' needs. So, as a conclusion, I could return to the initial question, can mediation become a trusted mechanism in resolving investment disputes? And here I could outline experiences growing, mediation is applicable to many investment disputes, enforcement frameworks enhance reliability, and what? What do these developments actually mean for trust in investment mediation? If we step back from those four pillars, a more fundamental question appears. What creates trust in dispute resolution? And trust, from my perspective in dispute resolution, comes down to two simple ideas. First, parties should control the outcome. And mediation offers this luxury and opportunity. And second, mediation, any dispute resolution should prevent from escalating into prolonged and costly conflicts. And mediation does this with its two other dimensions, deal mediation and project mediation, which are very relevant in investment projects to prevent conflict and to develop trust in mediation as a mechanism for resolving investment disputes. Thank you for listening. Hopefully we will meet one day in Ukraine to participate in this wonderful forum in person. So thank you for this enormous amount of work, Luisa and the team. Thank you so much.
Дякую, пане Фідане. Дякую вам. Ми обов'язково зустрінемося і дуже сподіваюся, що це буде
Thank you,
вже
Ms. Vidana. Of course, we will meet and hopefully it will be soon. When I read the topic of your report, it sounded like a challenge, like can mediation become it? Yeah, and you dispersed all doubts, and we now can say, yes, mediation can become a reliable mechanism for dispute resolution. And it makes restoration of relationship effective. Thank you, Ms. Fedana. So I suggest to move forward. Our next speaker, Leah, is the consultant and is part of the World Bank. She's specialist in the international investment and commercial arbitration. Leah participates in projects which involves many countries. She is secretary of the arbitration tribunal. Today she has an interesting topic to present, considering that Ms. Leah represents the international practice. And we all know about the experience and we are happy to hear you out and what can we learn from your experience, your tremendous worldwide experience. And we would be discussing the Dispute Resolutions Center and on provision of services. So, Ms. Lea, the floor is yours.
Well, thank you. Thank you very much. I hope you can all hear me. Good evening. My name is Leanne Jeroge. As you've heard, I am counsel at ICSID, and I'll let you know a bit about ICSID and what we do. But when I read the topic about trust and, developing and building trust in the area of dispute resolution, I immediately thought about cars. I know women and cars, maybe not a great topic, but I immediately thought about when you have a brand such as Mercedes, you understand and you trust that it has the attributes that you're looking for, which is the sleekness, which is, that it has a powerful engine and things like that. So it's built for that purpose. And then when you think about if you want to go on a rugged terrain, you would not necessarily pick a Mercedes for that, journey that you want to take. You'd pick a more hardy vehicle, a more hardy SUV, such as maybe a Forerunner or a Lexus or a Defender, something like that, And so when I was thinking about what to show you at ICSID, it's the whole point is about the options, the array of options that you have at ICSID that can help you, the parties, pick and choose the option that works for them both, which is available. And I know we're talking about mediation, so I'll get to what in mediation at ICSID is all about. So let me share my screen and do the presentation. I hope you can all see that. Okay, give me a thumbs up. A thumbs up that you can see my screen.
Так, видно.
Yes, thank you. Okay, thank you. So when, as I explained about the ecosystem of trust, it's about the entire system. That why do states want a favorable regulatory framework? And the whole point is that when you want a stable climate, the investors, as the speaker before me has just shared, that they want to know that they can come to a country and do the investment. And ICSID participated in one of the World Bank's flagship publication, which assesses the business climate and does a quantitative assessment of the private and business landscape. And what came out of that report is what I have in quotes on my slide, which is the efficient and quality dispute resolution is essential for a healthy business environment. Now, with that in mind, how does an effective dispute resolution system help to create that trust? And one of the reasons is because an effective and impartial dispute resolution is the cornerstone for investment. As we've already seen, an investor can trust that the system, whenever there's a dispute, if there is a problem arising, that they have options, that they can pick and choose an option that would work and suit best for them. And that's why we're here talking about mediation. Now, the main reason that we want to talk about why dispute resolution is effective is because it reinforces predictability. You know that there is a step. After this step, there's a next step. It also mitigates the risk associated with foreign investment. It also makes investors confident that their investment is secure because they have all their risks surrounding legal risk covered. So the second thing that around the importance of effective dispute resolution is to ensure the continuation of investment projects. The speaker before me and also Mr. Hussein also shared about how when you want a relationship to continue, it's important that you integrate into the system a system that ensures that the project itself is not stalled by conflicts that come up. So this is why you need a system that has integrated the effective dispute resolution. And the third thing is that also within the big group, the big main point of World Bank, which is to promote investment to secure jobs. So building an effective dispute resolution mechanism will foster stable and predictable investment climate. So ICSID contribute to the economic growth and job creation in that regard. So what are the types of processes that you can pick and choose? So here I've just outlined in this stage the different types of choices and process choices. I will not go deep into that because we already know them, and I'll talk a bit about them. So you have the direct negotiation, conciliation, mediation, arbitration, and you also have multi-tier dispute resolution clauses. Now, when we talk about ICSID and why it was created, ICSID is one of the 5 member organizations of the World Bank Group. It is the only non-financial arm, meaning that ICSID does not involve or does not have projects that relate to granting of loans or grants. So ICSID by itself was established by the Washington Convention, or the Convention on the Settlement of Investment Disputes, also known as the ICSID Convention. And the main reason why ICSID was created was during the time in the 1950s and 60s, there are catalysts and a number of factors that led to its creation. One of the main ones was that the president of the World Bank at the time, Mr. Eugene Black, was asked multiple times to intervene and use his good offices to help resolve disputes. Key among them that I'll show you a slide about it is the dispute concerning the Suez Canal and its nationalization by Egypt and the compensation that had to be paid to these investors. So ICSID has a history of integrating this kind of dispute resolution mechanisms into the system. That's how we started. And in a way, I will show you how we are going back to that heritage of resolving disputes. Now, you know ICSID mostly as an arbitration institution. And when we created the 2022 rules, we came up with a standalone mediation rules, which were not there before. And if I may show you on my screen, this is the booklet that that ICSID uses for mediation. Now, let's move to how ICSID is integrated into the One World Bank Group. So ICSID has a unique position in that it promotes international investment by promoting facilities. So we do not actively go and get investments, but we offer a space where should investors have a problem with their investment, they could come. We offer innovative features, particularly in arbitration under the convention, where the member states of ICSID are required to recognize arbitration awards as if they are a judgment of their court, of the state's court. So you skip that step of enforcement, and that's why the trust element comes in, because when an investor comes to ICSID, once they get an award, the ability to enforce it is usually not a problem at that stage because of that innovative feature. Now, we've also, I'll talk about mediation and how arbitration and mediation is different in terms of enforcement, and we'll see a slide about that. So our role is foundational in that we help, we promote a mechanism for resolution of disputes, particularly with the types of dispute settlement options that we have, and I will talk about that. We also talked about we help mitigate country risk, because when an investor is shopping or is looking for a destination for their investment, the fact that a country or a state has signed up, is a member of ICSID, usually ranks very high up, and this will help mitigate the risk. And particularly when you look at how the convention was established, many of the states that signed, they signed because of this very reason, that they wanted to attract foreign direct investment to help grow their economies, because at the time, many of the countries that first signed the convention were growing and developing, and they needed to gain that trust. So by becoming a member of ICSID, you are already, if there is a score for trust, you're already making pluses in the score. And so as a result, membership at ICSID is equivalent to having a trust in a system, is equivalent to having that protection that the speaker before me talked about, that if you come to a system like ICSID, you are protected as an investor because there's that careful balance between what the host state can regulate and what the investor wants, which is trust that if they do have a problem, that their dispute will be resolved in a fair and impartial way. So this is I think let's go to the next slide, which is this is the current map of the member states of ICSID, and the blue states are the states that have signed, and the yellow states are the signed as the signatory states, which means they have signed the ICSID convention but have not yet ratified or put in place local mechanisms to become a member. And then we have the grayed out states, which are states that have never signed the convention. So ICSID structure works like this. We have two basic levels. We have the Administrative Council, and which is made up of all the ICSID member states. Will have one representative each from each member state. Their functions are on the screen. I'll not talk much about that. And then for the Secretariat, I belong to the Secretariat. So we have a staff of about 70 people, and you'll see a picture down there. And we help the parties, and we provide administrative services for all the functions of ICSID. And we also provide technical and training assistance and publications for this. And one of them is the fact that one of ICSID's, okay, so this is a list of all the services that ICSID provides. So the blue row is all the arbitration types of arbitration that you can have at ICSID. You can have ICSID convention, which is under the convention, and arbitration under the ICSID convention has very specific criteria to meet. So, and that is outlaid in Article 25 of the ICSID Convention, where you have to be an investor and you have to qualify under the instrument of consent. And the instrument of consent could be a contract, could be an investment law, or could be a bilateral investment treaty. So there are very specific jurisdictional requirements that you have to meet to qualify for arbitration at ICSID. Then we have conciliation, which is also similar to arbitration, but not the same as conciliation under ICSID. You have to meet the convention requirements as well to access this. We also have arbitration under ancestral and ad hoc arbitration, where we offer administrative services for them. Then we come to mediation and fact-finding. So I brought also with me the books that we use. So the red book is the fact-finding. This is also a creation under the new rules. And then if you see the yellow, they're color-coded. I'm not sure if anyone can see this, but you have the yellow one, which is, when you see yellow, is the additional facility, and the blue is for the convention. So ICSID offers choices and that help parties resolve their disputes in a way that they can trust the system. That ICSID has been doing this for a very long time now, 60 years. We just celebrated 50-year anniversary of when the convention entered into force. So this is something that we have provided services for. And moving on to the next thing, the phases that we're now moving into, we realize the parties are coming to us, asking us whether you have model clauses for this. We last published this a long time ago, I think in 1998, and we have not yet updated them. But now we're working on a project where we are updating our model clauses, right? And so we'll have this available for where if you want to do when you want to pick and choose an option that works for you, whether it is mediation, whether it is conciliation or arbitration, we have those models that are available on our website. I'd also say one thing before I move on, that the model clauses are also very suitable for contract cases. I think it is Speaker Ahmad Hussein who talked about arbitration, who talked about contracts and PPP projects. So this is also something that ICSID is pushing towards, where you integrate ICSID as a whole into the projects, into PPP projects and contractual basis. A large majority of the cases that we see at ICSID have a contractual basis, and we're working on a project for contracts which will be released soon. And this is one of the things that we're moving towards, which is to promote ICSID dispute resolution in contracts. So if I may sum up everything that I've talked about, including our services, this is just a snapshot of what you can access at ICSID. So you have your arbitration convention and party 1 and party 2. So when it comes to mediation, just focus on the green part, see that you have green, green, green everywhere, which means that we've now opened up mediation. Mediation is no longer just, mediation is not limited to the type of investor, whether they meet the nationality requirements. So we've opened up even to include REIOs, which are the regional integration communities, organizations. So any state or constituent subdivision or agency or REIO, what we call REIO, and an investor, even if they're not a member state of ICSID, from anywhere across the world can access the mediation. So now we'll move on to discussing ICSID mediation. And I briefly spoke about how the World Bank developed and how it started off by the good offices of the former president of the World Bank, Mr. Black, and he helped to mediate the Suez Canal dispute. And this is also, there have been involvement, not just the Suez Canal, but the World Bank has been involved in very many disputes to help and assist the parties move forward, because the World Bank aim is to promote investment so that jobs can grow and the economies can grow. So having or adopting this early method was one way in which World Bank has helped in the past. But now, as I said, in a way, we are moving towards that again. So how did we get to mediation, and how did we get our new set of rules? So in 2021, we published the overview of investment treaty clauses on mediation. And because we realized that the data that we have is that a third of the ICSID arbitration cases discontinue or settle. We know that parties are negotiating, and they mainly come back to ICSID because they want that award embodied in a settlement, the settlement agreement embodied into an award, so that they can have the enforcement mechanism of ICSID. So this is something that we are offering to the parties, which we've also noticed there's a trend to consider ADR as an effective tool for dispute resolution. And that's something that we want to capture. You want to capture that and offer the parties a mechanism that can assist them with the process. The issue with mediation, as many speakers have said before me, is that yes, you will have a result, which is an award, but what if you want to continue the project? What if the parties are still in a working relationship? We've seen that contentious proceedings such as litigation and arbitration are not the best tool. They're not fit for that purpose. And that's why ICSID has created these rules. And we've seen that a lot of the bilateral investment treaties will include a provision to first do mediation and then try arbitration. So, and then we've also talked about the adoption of the Singapore Convention, which has helped to overcome the problem or the challenge of enforcement. So what is investment mediation at ICSID? It's a flexible process. I'm sure many of you will know what it is. I do not need to describe it, but the main point I want to say is that for us at ICSID, it will involve a state, a regional economic integration organization. So what is the framework for mediation at ICSID? And here we see that ICSID has a framework, which is the book that I showed you. So we are authorized under this book by the member states themselves who negotiated this. And the Secretariat were authorized to administer arbitrations where it involves a state or regional economic integration organization, which relates to an investment, and the parties have to consent in writing. And as I said, there is no nationality or membership of ICSID. You do not need to be a member of ICSID. And the request only needs to contain an offer to mediate. And I'll talk about that in the next slide, where we see how can you access mediation at ICSID if you are not do not meet or want to access ICSID at mediation at ICSID, but you do not have an agreement. So we have MR5, which is the agreement to mediate, and the sources for mediation. Sources for the agreement to mediate are the contracts. You could have a contract, you could have ad hoc agreements, domestic legislation, or BITs. So that could be one source. And on the other hand, what if you don't have an agreement to mediate? Can you access ICSID mediation? Absolutely, yes, you can. And all you need to do is to have an offer to mediate. You need to write, you can write to ICSID and say that we offer to mediate. Then ICSID will transmit that offer to the other side. And then if the offer is accepted, then we register the mediation. If the offer is rejected, we have a 60-day period in between where if either we do not receive we don't receive any acknowledgement from the other side which you have offered to mediate, and we do nothing about it, or if the offer is rejected, that is the end of the matter. Now, let's look at what are the principles that govern the process, the mediation process at ICSID. So one of the principles that was highly, I would say, valued by the member states was confidentiality. So everything about the mediation stays confidential. So unless the parties agree otherwise, or information is available online or disclosed, or you're required to disclose by law, ICSID will not publish information relating to mediation on our website, absent the parties' agreement. Then you have the principle of ongoing consent, which is a party can withdraw from the mediation at any time, which relates to what Ms. Fidana was talking about, which is the most highly ranked principle of trust is that the party has an option, that it's a process that is controlled by the parties. So this is enshrined in MR 22(1)(c), which means that a party can withdraw from the mediation at any time. Then there is the without prejudice principle, no dual roles for mediation, and costs. The next thing is I would like to do, I have just one more slide and then I conclude, is when can you use mediation? And when you compare mediation to arbitration, there are certain elements that have to be met when you decide to go to arbitration. Then that is the blue line here. So there must be a dispute. So arbitration at ICSID, you cannot just come at the early stages of a dispute. If it's an arbitration, there has to be a notice of intent to arbitrate, which will be your pre-action letter that you sent, a letter before dispute. There has to be those kind of triggering steps for you to get access to mediation, to arbitration. And then there is the cooling off period. There's the initiation of the arbitration where you actually file a request for arbitration. And then at the end of the process, it is expected that you get an award, unless of course you discontinue or settle. So that is the arbitration process. And the only step where it's triggered is when you have a dispute. Like when you see the box there, it's only from when you have a dispute that arbitration is triggered. However, in mediation, you can use mediation any stage of the dispute. You can have a mediation at the outset. You can have it during the project operations to resolve minor disputes. So essentially, it's a process that can be tailored to the parties' needs. So the last thing that I want to talk about is how about enforcement? And we know that there is there has been an issue about enforcement with mediation. So we wanted to show on this slide, what options do you have when you do mediation and when you have arbitration? So when we start with, let me start with arbitration. So when you have arbitration, you have an award, right? Which is, could be embodying a settlement agreement. And many parties do this. They stop the arbitration, they do the settlement, and then they request the tribunal to embody the settlement agreement in an award, which can then be enforceable. And so on this side, you can enforce it under the under the ICSID convention. And as I said, if you're a member state of ICSID, you can go to any country and have it enforced. So the next thing, you can have the New York Convention. You can enforce a New York Convention. If you have an arbitration under the ancestral or additional facility, then you also have your domestic litigation process as an option. How about mediation? When you come to mediation, if you have a settlement agreement, there are various pathways for you to enforce the settlement agreement. You have your Singapore Convention, you have domestic litigation, and you have arbitration as one of the options. So this is why you could say that mediation could be like one, you start with mediation and then go into arbitration. But however, the main thing that I want to leave with you is that there are options that are available to the parties, to investors, when it comes to investment mediation. It's about choosing the process, choosing the attributes of the process that you prefer or work for you or your client. And we have been involved at ICSID with many arbitrations that first, maybe they started off as an invitation or an offer to mediate, but they did not materialize. So those are options that I want to say that the parties in dispute are considering and that we have seen in our experience. And for Ukraine, this could be I think a gateway or a good learning experience where Ukraine could learn to offer many options which the parties could then use, because everything in the dispute settlement world is adapting to the needs. And one of the needs is to provide the parties with options for dispute resolution, so the institution and the country and the state can build trust in the options that they build. So thank you so much. That is it from me.
Дякую, пані Лея, за вашу доповідь. Звісно, що у нас дуже обмаль часу для того, щоб детально
Thank you, Mrs. Leah, for your talking points. Of course, we do not have a lot of time to cover all the instruments within ICSID. However, I believe that we will have more meetings with you and we will ask you later on to talk in details about your work and about your practice. Thank you so much for highlighting that a dispute cannot be a reason to finish the investment process. It is just one step, and we should not be afraid of that. Colleagues, unfortunately, we have lack of time. We cannot answer the questions. Please write your questions down in the chat, and we will ask the speakers to write down the answers. We have already overlapping with the next panel discussion. Thank you so very much for your attention. We have discussed very interesting information. Wrapping up, I would like to say that I am sure that arbitration and mediation history already exists in Ukraine. It is tiny one, however, it already exists. Thank you for your attention. Thank you so very much. Dear speakers, thank you so very much. I'm really glad to see you all. Thank you for your insights.
І саме сьогодні у нас такий день, коли ми показуємо, що це не просто, да, там щось про психологію десь
Of course, sometimes we talk about psychology, but now we are talking about multi-million issues which can be solved by mediation, by other procedures which exist in the ecosystem, which will contribute to the recovery of the countries which suffer from the war. Thank you so very much. And now we will move on to the next topic. And unlike the previous panel, where we had a lot of personal acquaintances, I actually remember our first meeting with Yemen, whom we have met at the international competition in Paris within ICC, and we were newbies. We did not know anyone there, and we just decided to stick together because we did not know any other people. So were actually lost a little bit. And since then, we made friends, and we keep in touch. However, and now I will pass the floor to Mrs. Jennifer, and we have a different story with her. Since 2023, Ukrainian Academy of Mediation systematically tries to find the paths of thanking our veterans, our defenders, men and women. And of course, we cannot thank them yet. However, we can thank the veterans. We can help them to get adopted to the civil life, and we may share our skills with them. And actually, we initiated the program since 2023 for the veterans whom we try to help getting a new profession. And this profession might be useful for communication in their families and getting some new profession. We actually did not have a prior experience. However, at a certain stage, I started consulting AI. We even gave it a name, Jorik. So I was asking Jorik to help me finding colleagues who works with veterans. Thus, Jorik found me Homefront Strong. This is an organization which cares about veterans, which deals with veterans, which has a lot of correspondent programs. Of course, Jorik says a lot of stuff which we cannot believe in. However, after me researching and consulting their social networks and stuff, and then I just wrote down a cold letter. And I'm really thankful for a very swift reaction and for a willingness to get together and to cooperate. Since then, we have even organized a common training in April. That was a training for veterans which helped them to talk about the mediation. So thank you so very much for what you're doing for veterans, for your support, for promoting the mediation. I will not represent anyone now. I will not introduce the speakers right now. However, I would like to say that this panel is composed of the veterans from Ukraine, from the United States, and from the United Kingdom. Chris, thank you so much for joining us. So I was searching for veterans from all over the world. So that's it from my side. Get ready to listen to the live stories about profession of mediation and the experience of the veterans.
Okay, thank you so much, Louisa. Can you hear me okay? Thank you. Excellent. We're honored to be here. We are honored to be invited to participate in this panel. My name is Jennifer Boblitz. I am the Executive Director of Homefront Strong, and welcome everybody to After the Frontline, Veteran Stories and Mediation. As Louisa mentioned, we have an esteemed panel here with us today, veterans and military family members from all over the world, spanning multiple generations, with a variety of experience in military service. They've prepared stories of how mediation has positively impacted their work with veterans in the past, and we plan to spend our time in conversation, hopefully offering some inspiration for how we can all apply mediation to our work with veterans and military families in the future. I am here today with my co-moderator, Sharon. I will be guiding our discussion alongside Sharon. But before we officially begin, because of the fantastic turnout at this international forum, we will not have much opportunity for engagement with our participants. However, we do want to encourage everybody to enter their networking information into the chat and then to save that chat for yourself at the end. Also, if you scroll in the chat, there is a link to a Padlet. If you click on this link, you'll be brought into a Padlet where there are multiple sections available for networking. There is a section dedicated to veterans and those who are working with veterans and military families. So please feel free to open that link, enter the section for veterans, add your information, and then you can engage with this fantastic international network long after this panel has concluded. And of course, I want to strongly encourage everybody here to enter their information. I myself will be entering my information into the link. As Louisa mentioned, it was about a year ago that I received a cold email from Louisa, and in the intervening year, we've had an opportunity to offer a variety of workshops to veterans and people working with veterans all over Ukraine, the United States, and it has been truly one of the most rewarding experiences, not only for myself, but also for my team. That has led to a tremendous amount of personal growth. So again, we're truly grateful to be here with this international community and engaging with our panelists from all over the world. All right, let's see. Before we get started with our panelists in the conversation, I want to just take a few moments to introduce myself a little bit more, as well as my co-host Sharon, and then I will go right ahead and dive into introducing our panelists. Again, I am the Executive Director of Homefront Strong. We are a nonprofit in the state of Massachusetts dedicated to building resilience among veterans and military families through programs that encourage community, connection, camaraderie, and increased access to resources. In addition to my nonprofit sector work, I am an adjunct professor at Assumption University, also located in the state of Massachusetts, in the Human Services and Rehabilitation Studies Department, as well as the graduate program for school counseling. In addition to my professional experience, I'm a military spouse of more than 23 years. My husband serves in the United States Air Force, and that has, of course, afforded me a unique perspective on the needs of veterans and military families. I became involved with veterans mediation back in 2018 when it was still a program created by Sharon Tracy, my co-moderator, and her partner, Susan Wallace, with their nonprofit, Quabbin Mediation. After training under Susan and Sharon in 2018, I quickly became a mediation coach and then later trained to become a mediation trainer in 2020. And of course, when Sharon and Susan decided it was time to retire and pass the baton, I was more than happy to receive the program and find it its new home at Homefront Strong. So with that, I'm going to pass it over briefly to Sharon so she can introduce herself and provide a few remarks as well.
Thank you, Jennifer. My name is Sharon Tracy, as she mentioned, and I was so deeply grateful when Susan and I retired from Quabbin Mediation that Jennifer and Homefront Strong took over Veterans Mediation. We created it in 2008, about 10 years before Jennifer got trained, in Massachusetts. We received funding from the state to make it happen. And I should say that the reason we created it was because I was raised in a multi-generational military family. My father, my grandfather, uncles, et cetera, et cetera. So I understood that there is a cultural difference between civilian and military life. And in accordance with the principles of community mediation, in which you want people from your community mediating for you, we decided to create a program that trained veterans to be mediators, and then went on to train some of those veterans who were interested to be mediation trainers. Steve Connor, who is one of the panelists today, was one of the first people who helped get the program going. And in fact, all of the people from Massachusetts who are going to be panelists were trained through our program. Well, so the train the trainer model is a power multiplier. You have people who can go out and train more and more people. We train thousands of people throughout Massachusetts and, in fact, in the United States as a whole. So really happy to bring the concept to a more international platform, and really happy to have connected with Louisa and the Ukraine Academy of Mediation. There's a lot of similarities between the work that we do, and it has been a really wonderful experience for all of us. So I encourage everyone to consider the concept of training veterans to be mediators, both within the veteran community, but also for the broader community itself. And with that, I will reiterate that really happy to be working with the Ukraine Academy of Mediation, and I'll turn it back to Jennifer to introduce the panelists.
All right, thank you so much, Sharon. Of course, I have the distinct honor of introducing our panelists. I will start by just going down the list. Panelists, when I say your name, if you could just give us your location, military connection, and other professional credentials. And then once we've made it through the list of panelists, I will go to each of you to start by sharing your stories. So first panelist is Harvey Weiner.
Oh, hello, my name is Harvey Weiner. I am a mediator, a Vietnam War veteran, and a longtime attorney.
Thank you, Harvey. Our next panelist is Ludmila Minuk.
Я ветеранка,
I'm a
психологиня.
veteran, psychologist, and mediator.
Thank you, Lamidia. And of course, Lamidia is joining us from Ukraine. Next on the list is Chris Breeden. Chris.
Hi, everybody. Thank you for having me here. I'm Chris. I'm from the United Kingdom. I did 40 years in the Royal Air Force, and I'm now a professional mediator and mediator trainer.
Excellent. Thank you, Chris. Next on the list, we have Pedro Spivakowski Gonzalez.
Hi, everyone. My name is Pedro Spivakowski Gonzalez. Thank you so much for having me. I'm a lawyer and a mediator, as well as a U.S. Army veteran. And for the past 5 years, I've also taught negotiations at Harvard Law School. I'm located in Boston, Massachusetts, but we recently had a Ukrainian family visiting us, and they brought us a hustka. So I feel like I have a memento of Ukraine here with me as well. Great to be here.
Great to have you, Pedro. Thank you. Next, we have Vladislav Zuravel.
Hello, I'm from Ukraine. My name is Vladislav Zhuravel. I'm former missile launcher. Now I'm project manager in NGO Razom for Ukraine, and I'm also the member of Village Council.
Excellent. Thank you so much, Vladislav. And last but never least, of course, we have Steve Connor. Steve? All right. It appears we may. Oh, Steve, are you there?
Okay.
There you are.
I have permission now. Okay, I apologize. I'm Stephen Connor. I am a Navy veteran. I also am a veteran service officer in Massachusetts, assisting veterans with benefits and programs.
Excellent. Thank you so much, Steve, for being here. All right. So to kick it off, we're going to go back to the top of the list. Harvey, you've been a longtime member of Veterans Mediation here. You are a lawyer. You are a mediation trainer and a Vietnam veteran. Can you share a little bit more about your experience serving in that capacity?
I'm glad to do so, Jennifer. First of all, thank you for inviting me. I wish everybody, as the case may be, a good morning, a good afternoon, or a good evening, depending on where you're located. And I go way back. In the 1960s, when dinosaurs still roamed the earth, I went through United States Army Officers Basic Training at Fort Devens, Massachusetts, and then United States Army Infantry Officers Training at Fort Benning, Georgia. There it was drilled into me and into every other soldier that losing a battle in combat meant not just defeat, but also torture or death. And that to prevent this, I must embrace the spirit of the bayonet, which is to kill. Now, I carried that spirit and that will to win within me throughout my entire year in Vietnam in a combat situation, and thereafter in my litigation law practice. In all my subsequent legal cases, it was my goal to win, but if I would not win, I would still battle as hard as I could, which might intimidate my opponent into a favorable settlement. I usually had the additional advantage because I wanted to trial, since I love to try cases. I love the battle. It was like being in combat again, the same adrenaline high. I learned that many lawyers I opposed and their clients were reluctant to try cases. In fact, many times my own clients preferred to settle the cases. You see, in those ancient days, those Jurassic days, there was no such thing as alternative dispute resolution, or ADR. I was not taught it in law school. I'd never heard of ADR. Very few lawyers had ever heard of it in the early to mid 1970s. Why would clients pay for a third-party meddler when the attorneys involved knew how to negotiate and how to settle cases themselves without any outside help? Now, for reasons I do not recall, in the mid 1970s, I became involved in my first mediation with Eric Green, one of America's first mediators, a pioneer, who, by the way, is still mediating. An unusual procedure, I thought. It could never catch on. However, over the decades, I have been involved in hundreds of mediations, almost always representing one of the disputants. My wife, who is not an attorney, became a certified mediator. My thinking then evolved as follows. First, I believe that because the downside of losing after trial is usually so much worse than the upside of winning, that the risk of total defeat is eliminated in mediation. Second, the angst, the expense, and the loss of time at trial is eliminated. Third, the resolution is in the control of the parties and not a fickle jury or an irascible judge. Finally, I understood that if both sides agree to a mediation, it is more likely that it will be successful and fair, even accounting for buyer's remorse. My spirit of winning was not always in the best interest of my clients, and my experience in mediation tempered this. Still, I missed the frequency and high of actual trials and the thrill of victory. Then, about a decade ago, retired Massachusetts Supreme Judicial Court Justice John Greaney told me that military veterans were one of the least served groups in the American legal system. They were somewhat invisible as a group to the legal community and had unique legal needs specific to veterans. An example is readjustment problems after deployment, leading to major domestic issues. A deployed veteran who comes back is a different person than the soldier who went out. We all know this. I knew that many of them must have had that same spirit of winning that I had. And they, like I, had been trained to settle their disputes by violence rather than by peaceful means. And that's how a soldier is trained. I believed I could help them if I were properly trained in mediation skills. Fortunately, thanks to Sharon and Susan Wallace, there was a unique state-funded program in Massachusetts called Veterans Mediation, and I believe unique in the nation. I was trained by them and became a certified mediator with an emphasis on veterans. Since then, I have taught mediation skills to about 100 veterans, Massachusetts National Guard members, and individuals who work with veterans, including two people on this panel, Pedro and Jennifer. Now, although I have not yet lost my desire to try and win cases, I now know that compromise and peaceful resolution, usually through mediation, is almost always the best solution. And as to veterans, I hope I have prevented a few barroom brawls and a few domestic fights between spouses. The world must also learn the benefits of mediation and have their soldiers beat their swords into plowshares. Thank you for listening, and back to Jennifer.
Thank you so much, Harvey. I always so appreciate, one, your humor, and then, of course, listening to your story. It illustrates so well that intersection many of us who approach conflict dispute from different angles have to contend with when we truly adopt mediation into our practice and our orientation. So that's fantastic. Thank you. All right, next up, Ludmila. Ludmila is someone I have had the distinct pleasure of getting to know over the course of our webinars with Ukrainian veterans. I've been honored to hear her story. And Ludmila, the current war with Russia has impacted you and your family so deeply, and you've done so much in your professional role to try to improve the lives of veterans. Would you share a little bit more with us, Ludmila, about your experience?
Yes, I'm a psychologist and a mediator and a veteran, and I'm also mother of the deceased defendant of Ukraine, Stanislav Menyuk. Today, I would like to speak not only like a specialist, but a person who lives through war every day together with the veterans, the families of the deceased or missed in action with civilians and military personnel. The war leaves not only destruction of villages and cities, it leaves conflicts inside the families, communities, and country. People return from the front lines a different person. The experience often cannot be explained through words, and more often than not, community does not know how to listen to the veteran. That's why mediation is very important right now. mediation is not only a way to sort a dispute. It is a space of safety, dignity, and respect. It is an opportunity to be next to somebody without judgment. For veterans, it is always the first step towards restoring trust to people and live outside of war. In my work, I see how mediation helps restore relationship in the family, how it reduces strain between civilians and military, to how for communities to accept veterans without fear and bias, and to prevent deep social conflicts. For many veterans, it is very important not to hear advice, but to hear that they're being supported. And mediation creates such a dialogue. And right now, Ukraine needs not only restoration of villages and cities. We need to restore human connections, and mediation can be one of the key tools in this process. I'm convinced that where there is dialogue, there is a chance for renewal and restoration. Where people start hearing each other, we start having the path towards peace. I thank everyone who supports Ukraine, who supports my people who live in Ukraine. And I have thank everyone and Ukrainian Academy of Mediation for skills and knowledge. And I keep carrying those skills to everyone who needs it. Thank you, everyone. Thank you, colleagues. Each one of you is the example for me. And from the bottom of my heart, I can say that you are my teachers. Thank you.
Thank you so much, Ludmila. Again, I feel like I speak for our whole team when I say we've learned so much from your sharing your story and bringing all that you have to offer to these sessions. So I truly thank you and look forward to witnessing the work that you will engage in the coming years. So thank you again. All right, next on our list, we have Chris Breeden all the way from the UK. Chris, you are someone who served for many years. You've made mediation a centerpiece of your work, and you're using your business acumen to try to leverage those skills in helping veterans. Can you please share a little bit more about your story with the group?
Sure, yeah. So I was in the RAF for quite a long time before I'd even heard of mediation. But the way my journey started was I got myself in a little bit of trouble. And in the process of that little bit of trouble, I was ordered to attend mediation the very next day. And so I asked what the trouble was about, and I was told I would find that out at mediation. So I asked who it was that I was going to be mediating with, and I was also told I would find that out at mediation. So I hop, skipped, and jumped along to the mediation the next morning, and was met by the mediator, who turned out to be somebody that I was the boss of, which was a little bit strange because I knew that mediation should be voluntary, but I wouldn't push back. You know, I was in the military and I'd been ordered to attend mediation. But I also knew that the mediator should be completely independent and neutral. So I was a little bit surprised to find that the man I gave the annual report to was the mediator. And so it would also appear that we dispensed with my own individual meeting with him, and we went straight into the joint meeting where he just said to me, sit down and listen to this. And the people that had their problem with me basically gave me their story. And the mediator said to me, so what do you say in response to that? And I said, well, this doesn't really feel like a mediation as far as I'm concerned. So he said to me, are you refusing to mediate? I said, well, I'm not refusing, but this isn't really a mediation. I do know a little bit about the process, and so far, nothing seems to have matched up. But he said to me, well, if you refuse to mediate, I'll have to inform the commanding officer that you've refused to mediate. And I'm like, isn't this meant to be confidential as well? So basically, I did refuse to mediate and left. And I got myself in a lot of trouble. But 3 years later, when all that trouble was cleared up and I was completely exonerated, I decided that I would actually get involved in this process. I was already a trained mediator, but hadn't practiced at all for quite a long time. So I paid to get a civilian training course out of my own pocket, because the military don't support you in those sorts of things in those days. And then I offered my services to the military as a mediator, in addition to my other duties. And they took me up, and that was about 2015 that I became a military mediator. And then I did loads and loads of mediations, and I suddenly became overnight almost one of the most experienced mediators, because even though lots of people were trained, clearly some of them hadn't been trained very well, given my initial experience of RAF mediation. There was still only a very small number of people delivering the mediation. So the RAF then was about 35,000 strong. I can see the Americans thinking you can't have a military that's smaller than a US Marine Air Base, but trust me, we do. And of those 35,000 people, I think 12 of us were active mediators. So it was quite a busy time, in addition to my other roles. Ultimately, my time in the service ended. So that was a year ago, February. And I was sort of out on my own. But luckily, strangely for Chris, I actually put some thought into this before I was leaving, and I knew that at some point my military career would end. So about 4 years before that date, I set up my own mediation business, and was able to do that alongside having a military career. So I didn't have to worry too much financially. But so when I popped out last February, so that'd be about 14 months ago, my business was already set up. It was already running. I'd got myself a bit of a name out there on LinkedIn, probably not a great name because I'm a bit of a disruptor. I tend to challenge things that I don't think are right, etc. And in the UK mediation world, that's not very acceptable. But being a disruptor, I'm certainly known. So that's helped my business, because some people just like to come to me because I'm just a little bit forthright and blunt, a little bit unusual, I think, for an Englishman. But, you know, you pay your money and you take your choice. So all I can say, though, in response to what I've heard from Harvey, etc., is in the UK, we don't support our veterans at all, really. We like to think we do, but we don't. So the fact that you're a veteran and you're a mediator really cuts no ice with anybody. They don't care that you're a veteran. In fact, I know many veterans who no longer say they're a veteran if they're running their own business, because they believe it makes life more difficult for them. So there is no support out there. As far as I am aware, in the 6 years I've been running my business, I am the only veteran-manned, veteran-led, veteran-owned mediation business in the entire United Kingdom. That's not to say there aren't other veteran mediators out there, but they have all failed as a veteran mediation business and are now working for other agencies, etc. So being a veteran and being a mediator makes no difference as far as the UK is concerned. But what I've done with the skills I was given, as well as continuing to provide mediation, workplace and community mediation, is I developed a training program. Luckily, in my time in the military, I was trained to be a course designer, a trainer, a training supervisor, an assessor. So I added all those skills together and designed a small set of courses to help people manage conflict. One of those being a standard 5-day mediation course. I offer those courses to veterans, if not free, certainly at a very low price, but mostly it's free. I give the veterans that come on my course free through life support, as I do for all of the people that attend my training. They can come for me to any help to set up a business, or if they're having a difficult mediation, or if they want any support at all, I'm there to provide that for free. But there aren't many military. There are lots of mediators in the military, but they mostly come out and find getting into the mediation business in the UK is very difficult. Some of the professional organisations in the UK refuse to acknowledge military qualifications, and they put financial difficulties in front of those mediators, who then have to convert to other courses, which is unnecessary because the course is as good as everybody else's course. So in response to that, I set up an organization called the Confederation of Independent Dispute Resolution Experts, not solely to support veterans, but initially it was with the idea of supporting veterans for free through life support, learn from other veterans and learn from other people around the world. But I soon found that there was lots of civilians came to me for that as well. So that organization is growing. It's international, and we're all learning off each other. And there are several veterans that are joining that. But again, offers of support to veterans that are in the military from CIDA and my own business get met with a stone wall. Because pretty much in the UK, once you leave the military, you're out. They don't care. You're gone. And if you offer to come back and help their own mediators with free CPD and stuff, they won't have you back. It's very difficult to get back on a military camp in the UK if you're not invited. So the hurdles we face as a veteran in the UK are quite large anyway. But being a veteran mediator, it's probably much more difficult because initially your qualifications when you leave the military aren't recognised by the professional bodies. Bearing in mind in the UK, there is no statutory requirement, there is no regulatory body. We just have a couple of self-proclaimed organisations that make life difficult for mediators. It sounds all doom and gloom, and it may well be, but my intent is to continue with CIDA, continue to knock at the door of the military, and continue to shout from the rooftops that veterans come with a whole host of skills. And veteran mediators are probably the best people to mediate veterans. And that's a drum I'm about to start beating very, very loud. I do a lot of community mediations, and some of the organizations I do that for recognize that I'm a veteran and some of the people in the communities are veterans, and they know that just the fact that I can sit there with a man, see on the wall behind him his military history, we can have that chat, build rapport, talk a little bit about our shared experience in the military, and then ease into the mediation. So some organizations are beginning to realize that a veteran might actually be a better choice as a mediator for veterans. It just makes the rapport so much easier. But yes, that is my story in a nutshell. I will continue to plug along. We are about I have a very close friend who's an army mediator. I try not to hold that against him because he was in the army, but you know, you have to go with who you've got. And he and I are about to set up a UK veterans mediator network, which will be solely to support UK veterans in their journey into mediation. I'll let you know how that goes. We're launching that probably in about 2 months' time. So that's me. I'm Chris, grumpy, but still in the fight.
That's fantastic, Chris. Thank you so much for sharing. It's such a fantastic application story of really how you can leverage those mediation skills. And I'm fascinated to hear about how different your experience in the UK is as a veteran than it is here in the US for our post 9/11 veterans. But at the same time, hearing your story of your early experience and your razzing of your Army partner, there's so many common threads. So I really look forward to the conversation, what you bring to the conversation with the other panelists. Thanks again. All right, next we're going to move over to another member of the U.S. team, Pedro. Pedro is here representing the post 9/11 veterans, lawyer much like Harvey, and also someone who has a unique connection with Ukraine. So Pedro, the floor is yours.
Fantastic. Well, thank you so much for having me, and thank you, Jennifer, for that introduction. First, I'll just say, you know, my grandmother was born in Odessa, and I visited Ukraine before the war, so I remember a Ukraine at peace, and so it's really an honor to be part of this panel to talk about conflict resolution and how best to serve veterans. So as Jennifer mentioned, I'm also a U.S. Army veteran. I deployed to the Middle East and have served in uniform in a number of different countries around the world. Providing training to partner forces on human rights law and international humanitarian law, Of course, as mediators, we recognize the importance of peace, but of course, when there is war or until there is peace, it's important for every country to follow the rules of international law as well. And so I trained Ukrainian forces in international law, and I've met Ukrainian soldiers that were on the front lines, and then had the opportunity to speak with them afterwards. But I've also met Ukrainian mediators and heard more about mediation in Ukraine. So I'm glad to be here for this discussion about conflict resolution, and looking forward to learning more. Just to tell you a little bit more about my journey, my path in mediation. When I was in law school, I took a few negotiations courses, including actually with Bob Nukin, who Harvey mentioned, I think. And I remember being very interested in alternative dispute resolution, both at the local level and also at the global level, and how it could have impacts, around the world, starting in the community level, but also in much larger contexts. And so my other main focus in law school was legal aid, was wanting to become a legal services lawyer and attorney, helping folks that don't have access to legal services. And so when I graduated, I became a legal aid lawyer for low-income veterans, and I represented and assisted veterans in different local courts in Massachusetts, different types of cases, mainly civil legal aid cases, whether that was representing them if they were getting evicted or if they were going through a divorce, or needed some other assistance with regards to consumer debt or veterans benefits, and other issues as well. And it should, of course, is no surprise, I'm sure, to everyone here that when veterans come home from war, there's a lot of different challenges that they face, and that was certainly the case for a lot of my clients. And they faced legal issues that were related in different ways to their military service, whether that was because they had a mental health issue that resulted from their service, or some form of trauma, and then that was manifesting itself in something that resulted in a legal issue, whether that was in an eviction, right, or in a different type of legal matter. There are, of course, many homeless veterans throughout in the United States, so a lot of my clients were people who needed access to those services. And so in this time, I also had the deep privilege of meeting Harvey, who you heard from already, and was also very involved with this legal aid organization. And not only that, but is also the person who introduced me to veterans mediation. So I took a mediation course for veterans and veterans advocates, and really kind of dove right in. And I had represented veterans in mediations, and I think we've talked a little bit about what the differences are when you're going to trial versus when you're trying to settle or mediate a case. And going through those conversations with my clients, was really, really powerful. But I could start to see the wheels turning for them of, how can we engage in these conversations? And so I was a veterans advocate before I became a mediator. And I want to just spend a couple of minutes talking about how mediation can help veterans. I really think it has a transformative power, not just impacting the person that is mediating, the mediator, but also the people that are having their dispute resolved and their case mediated. In terms of how it impacted my life the past several years, I was in the legal aid and access to justice space, but also teaching as a lecturer on law in the Harvard Law School negotiations program. And at that time, like I said, thanks to people like Harvey, Sharon, and Jennifer, who were part of that veterans mediation training, became a mediator. And after doing legal aid work for most of a decade, I then became the director of a community mediation center in Massachusetts, the Community Dispute Settlement Center. That has been around since the 1970s and serving thousands of people in the greater Boston area with different forms of conflict resolution services. And so not just mediation, as we've talked about today, but also training, facilitation, and other conflict coaching services. That would be in the courts, so whether that was small claims cases or eviction cases or in juvenile court, and then also outside of court in helping people just in the community mediate their disputes. And we had a wedding band that called us and was having a conflict, and then they then referred a marching band to us. So I like to think that we even were improving music in the community. But I really think there's a multiplier effect to these kinds of mediations that really has a particular impact, with veterans for a number of reasons that I'd like to just share very briefly, which is, veterans are continuing to fight after they come home. There's an ongoing fight for the rest of their life, a struggle regarding the memories and the trauma, but also for very concrete things like healthcare or benefits. And those challenges of war don't end when they come home. And so one reason that programs like mediation for veterans are really, really important is just the types of skills that it helps to build with veterans and also the type of confidence that it helps to build. So just to name three things, I think like the focus, for example, on active listening and learning to empathize with people and really trying to understand the stories that people have. That's one aspect of a mediation training that's really, really valuable. And then I think a second one is also reframing, because we talk about reframing as mediators and moving from the negative to the positive, from the past to the future. And it's a really, really key mediator skill, but it also, I think, is important for veterans to think about how they're trying to reframe their lives from conflict towards peace, and becoming a mediator can really help with that. And then I think third, really just the creative thinking and problem solving in community mediation. Of course, as we talked about in the previous panel, the solutions, they come from the parties and not from the mediators. But the idea of trying to build something bigger and better than what was there before and to think outside the box as well is really, really valuable. So those are some of the things that are really impactful about veterans mediation. And I hope that for veterans that are here, Ukrainian veterans and others will consider it in the future.
Excellent. Thank you so much, Pedro. It's so beneficial to hear from somebody who is so steeped in mediation at all the different levels. Oftentimes in our veterans mediation program, people will go through the training and they will say, the skills are so beneficial. I apply them on a regular basis, but I never get to do an official mediation. So it's wonderful to get that perspective from somebody who's done it, like I said, macro to micro level. So thank you so much for bringing that. Okay, next we have two more panelists to get to. The next panelist, we're going back over to Ukraine. Vladislav is a veteran who has had great experience in the nonprofit sector, advocating on behalf of his fellow veterans, and mediation has played a key role in that. So Vladislav, you have the floor if you would like to share more with us.
Hello yet again. So I would like to also thank everyone whose countries are joining on aid to Ukraine. Thanks to you and your support and your resources and your taxes. We can have an opportunity to continue this. So I would like to motivate you to keep on supporting Ukraine. So in 2022, I was the decorator and I was working in a decoration company. I lived in Kiev region, and when the war knocked on my door, I joined Ukrainian armed forces. My first battle was in Irpin, near the notorious city Bucha, and the specific feature was that there were a lot of civilians under shellings, and we needed to use intuition to see who is a spy, who is a collaborator, who just doesn't want to leave their houses. And we needed to motivate people to leave the battle line because they were a threat to themselves and to us. I have in my memory those who were not persuaded and who died. I kept thinking that maybe I could have done the dialogue differently so that they would change their mind. Unfortunately, we cannot go back. Once I was released from service, I went back to the civilian life because nobody is doing decorations anymore. Nobody is having celebrations anymore. So I lost a job. I wanted to continue help Ukraine, and when there was an opportunity to join the NGO, especially the International American Ukrainian NGO. This idea felt interesting to me, and I was accepted as a veteran, and I got an opportunity to grow. I started as assistant to project manager, and now I'm managing two of the largest projects of the whole fund. So, what is mediation? When I went back to the civilian life, I was hungry for study. I was hungry for life. I wanted to live. I wanted to learn. I wanted to know how to live and what I can achieve. And one of the breaths of fresh air was Ukrainian Academy of Mediation. A person I know sent me contact details, and she said, like, listen, you like negotiations and settling conflicts. You try to make people agree. So maybe you would like to do it doing professionally. And I started reading what is mediation, and I thought, like, oh, wait, so there is even a profession like that, and people are working in it. So I joined, and I was enjoying every lesson, and it was difficult because I needed to combine work and training. But I went through all that, and I'm happy that I had such opportunity. And I would like to thank Ukrainian Academy of Mediation for that. So, practical case. When you studied, you want to try it on practice. But when you come and go to people, I am mediator, let's sort your conflicts, it was difficult. So I was waiting, and I was waiting when I can show myself. And a situation happened where my chief was has issue with the Ministry of Defense, and they had such a huge conflict that they were all angry, shouting, and all on emotions and exhausted. And I just used the moment. I asked them questions to reduce the temperature, and I said that to the chief, listen, I finished the mediation course. Maybe I could be of use. And he was like angry. Okay, you're going to negotiations with us tomorrow. And he thought that he would show me that it is a difficult case and it is not a place for you. And for me, it was a challenge. And I was thinking dialogues in my head. I was decomposing this problem. And when I went there, everything seemed so easy because when you follow the procedure, when you follow the professional checklist, I found out their needs. I explained our needs. And I was listening more than I wanted to persuade them. And by using all those skills I learned during the training, something was intuition, because you still need to sort of feel the people. And it ended up in a way that the representatives agreed with us. And they didn't want to go into conflict anymore. They started helping us more than they helped anyone else. And we had this case, we became friends, we kept on cooperating. And up till this day, we are still have warm contacts. And this is a successful case. Unfortunately, in my life as a member of village council and veteran, I have such unpleasant thing when you face unfairness and where people just do not accept veterans. I cannot go into details, but we had a difficult case where, if there are a lot of data, a lot of information where we dissolve everything into molecules and atoms. And I'm happy that I have those skills from the training that I can use them even now. And to end it all, I would like to add that it is important to train veterans mediation. It is important for all societies, especially for our full-scale war. Mediators are those people who will be a bridge and who will be building a safe society. Thank you.
Thank you so much, Vladislav. And I just want to say, it's so apparent that your passion for learning and your work and advocating for veterans is infectious. And thank you so much for sharing that fantastic example of how you can really seize an opportunity to leverage mediation skills. I couldn't have planned a better compliment to Pedro's story than yours. So it's fantastic, and I really look forward to what you have to offer to the conversation. So thank you. Okay, that brings us to our final panelist. Coming back over to the United States team, we have Steve Connor, someone who has worked on behalf of veterans here in the state of Massachusetts for decades, who has contributed a tremendous amount to our veterans mediation program. And continues to use these principles and techniques even in his semi-retirement. So Steve, I'm going to hand it over to you and then ask you to launch us into the conversation with the other panelists.
Steve, I'm going to interrupt you just for 1 second because I have to leave. I'm so sorry. It's been really wonderful hearing your stories, and I look forward to, working together in the future. You guys all rock. Great. Thank you so much. I'm sorry I have to go.
No worries. Thank you so much, Sharon.
Bye-bye.
Bye. All right, Steve, the floor is yours.
Hi, Jennifer. Thank you. Thank you, everybody, for having me here. It's a pleasure. It's been a thrill to work with the Ukrainian panel and just what mediation can really do. Pretty briefly, I just would like to say I'm of the 3 U.S. veterans, I'm not a lawyer. The other 2 are, except I did play one on a stage once in a play, but that's beside the point. So an out-of-work actor, what did they end up doing? So I had spent a number of years working in human service. I was a Navy veteran from the late 70s, and unlike, Chris saying that people didn't want to acknowledge that they're veterans, I didn't want to acknowledge it as well for many other reasons. But I did have a job at one point in human service for a community action agency, and the director of that program left there. I left about 3 years later. She became mayor, and I went to work for another agency working with families with children or siblings that had developmental disabilities. And I'd been doing that for a number of years, and I got a call from my former boss and new mayor of my hometown, and she asked me if I would apply for the job as a veteran service officer. Well, my knowledge of a veteran service officer was very limited. And I said, well, I'm not very good at marching. I'm not great at ceremonies. You probably want somebody different than me. I didn't have any distinguished military career. And she said, no, what I need is somebody who can be from a human service background, because we have a lot of homeless veterans in our community. As a matter of fact, the city that I started in and my hometown has a very large homeless shelter program for veterans. So she wanted me to reach out and see what we could do. So I took that initiative. I applied for the job. I was given it. And at age 44, I'm now working with veterans again after a long time of not even being connected with any real veteran groups. As I did that, not only did I try to do the work there, but I was noticing that to really communicate with other veterans, that there are certain things I needed to learn. So I did a lot of different trainings. And fortunately for me, I ended up meeting Sharon. And she contacted me because she had this idea about veterans mediation and having veterans be the mediators or family members. And what did I think? And I thought, wow, that would be that'd be really good. And so she talked about training. Well, the first training that we had was at the university, and I was in the first class, and I think there was about 20 of us. And I learned to be a mediator, and I actually participated in some 2 formal mediations, which then gave me some street credit, and was all happy with that. But then when I came back to my job is to get veterans their benefits and provide services. And again, like I said, my mayor really wanted me to work on homeless veterans. So I discovered these skills came in very handy. Go a year or 2 later, I've been selected to join the lieutenant governor's commission to end and prevent veterans homelessness. And as a part of that commission, we did a lot of work. We came up with a plan. And what I can say is the part that really ended up being important was the prevention part of it. And so after I wrote the plan, I actually tried to take it into action. And what was my action? I showed up at the housing court every Monday for a decade and a half. I would go, I would sit with other agencies and say, if you're a veteran or the surviving spouse of a veteran and you're having housing issues, come talk to me. We have plans. The whole thing got kicked off from then President Obama about wanting to end veterans homelessness. So they came up with different programs. So I'm going to take a minute and tell you about one. I've had many, many cases through the housing court, but I had one gentleman, he was a tough case. The country came up with a plan and they called it HUD-VASH, but it basically meant that it's going to be supportive housing. It's going to use 30% of your income to pay the rent, and then the government would pay the rest of it. You'd also have a social worker work with you and a peer who would help you find a place and then stay in the place. And all the things that are involved in that, everything from getting furniture to getting stable to whatever it needed to be. And we had done this for a formerly homeless veteran. For the sake of recognition, I'm just going to call him Woody. I was in court. I remember helping him get housed. We helped him with first, last, and security, and everything seemed fine. And all of a sudden, about 8 months later, I'm seeing him in housing court. And so when we went to try to resolve the situation, I asked what was going on. He was in rental arrearage. And it was like, okay, well, now they've got a new program that can help with that. And I connected him with a grant program, and we paid his last 3 months of rent and got him all caught up and said, do you think you're going to be good going forward? And yes, he was all fine. Now, mind you, he served for a couple of enlistments. He then also had gotten married during that time. So when you're in those situations, especially in the military, you don't have to worry about rent. They're going to house you. You don't have to worry about food. They're going to feed you. His wife was on the outside and she would stay in the hometown, but he never really had to worry about any of those things. So I kind of chalked it up to that, and I told the landlord that that was probably part of the reason. About 5 months after that, he's back in court. And I go and I meet with him and the housing specialist trying to figure out what happened this time. And he was in arrearages. And I'm like, we just got through those other things. He's like, yes, but I'm having difficulty. And I'm like, yeah, what is the difficulty? Why are you having such a struggle paying your rent? He goes, by the time I get my money and my disability pay and this and that, I then have to pay my different bills. And the biggest one is my cable bill. And I'm like, no, your biggest one is your rent, but tell me about the cable. Turned out he had had a relationship and the woman needed to get access to the internet. And so the cable bill became his priority. And I said, we've got to work on that. Talked with the landlord again, said, we are going to work and we're going to go through a budget, which is what we ended up doing, and explaining how that it's important that he understand the landlord's point of view, but also his partner's point of view. What can we do to solve this? And through a couple of times sitting in my office, we decided that his partner could use the library and he didn't have to have the cable until he was able to afford it. It did finally end up working, but the fact that he had kept going in and out of court, the fact that I could use the skills that I learned through mediation to help him through both reframing what he was facing, both to the landlord, but also to him about the landlord and about his partner and how to look at things in a different way. And it ended up working. We bailed him out one more time, got his rent paid off, and he has now been permanently housed for many, many years. And I'm really grateful. But he learned something that he never had to worry about before, because when he was in the service, he didn't have to worry about those bills. And even when he got out, his wife did it until they split. His ability to handle money is probably why they split, but that's just my personal opinion. So the important thing that I found in court and when I take these cases is I am also a veteran who didn't have to do those things. And when I first came back, I had my own struggles trying to get into the civilian world and figure out how that all works and to be successful and to understand that I had these other responsibilities and that the civilian world is very different. So I guess what I would say to everybody here, my job as a veteran service officer, the requirement that the state has is that every city and town has to have somebody like me to work with the veterans and their families in the community. But more importantly, you also have to be a veteran to do it. So I guess I'm wondering, how does everybody else feel about when you go to help another veteran? Do they ask you, are you a veteran, or do you offer it because you know that they will feel safer with you or feel more connected knowing your status? People feel that way?
That's a fantastic question, Steve, and I'm going to allow everybody to answer in just a minute. I just want to be mindful of time since we've run over a bit. It is 1:10. I do know Pedro does have another commitment that he has to excuse himself for, so I just want to thank Pedro very much. If you have a final takeaway, we'd love to hear it. Otherwise, I'm sure Pedro will be networking in the Padlet if anybody is interested in connecting further with Pedro. So,
so much, Jennifer, and thank you so much, Steve, for the story. Where I worked with a number of VSOs, veteran service officers, as a legal aid lawyer, and the work that y'all do every day is really critical, whether it's on the HUD-VASH vouchers or everything else. Thank you so much for having me. And just in terms of a takeaway, I think it's really about veterans paying it forward as well. And I think that's a couple of great stories there that Steve shared. With that, thank you so much for having me, and Slava Ukraini.
Thank you, Pedro. All right. So let's plan on just a few more minutes so we can, I know there's another session planned for right after hours, just to be respectful of everybody's time. But Steve, what a great question, and what a great question to kind of wrap up on for everyone. You know, what is your experience working with veterans or military connected individuals in the community, and how your identity either facilitates that or otherwise? Any thoughts on that? Harvey, then Chris?
Yes, I'd like to pick up on that and also pick up on Chris's point. In standard mediation training, we're told that it's not important that somebody is that you disclose somebody as a veteran if you're dealing with other veterans. And the reasons and I don't agree with this, but the reasons are, if let's say you're a mediator and you're an officer and there's an enlisted man, that's one issue. Let's say one of the parties is a veteran and the other is a non-veteran, then that shows bias. But I feel that the whole purpose of veterans mediation is to have in part veterans who other veterans trust. There's a bond that veterans have between each other that's unparalleled, in my opinion, particularly war buddies. And one of the things we do as mediators is to try to develop trust. That's why we have open-ended questions, rephrasing, all that stuff, and appear neutral. But if the trust is already there because you're a veteran and the disputants are veterans, it seems to me you're ahead of the game. And I think that veterans who mediate veterans' issues are 2 steps ahead of any other civilian mediator. Anyways, that's my point in response to Steve and Chris.
Thanks, Harvey. Chris, go ahead.
Yeah, I think since I left the military and I've been doing more mediation in the community, where I've been asked by some agencies, you're a veteran, we know this guy is a veteran, that might help along. I think I'll agree with Harvey there. I think once people know you're a veteran, I think they just trust you, because most of the people I meet are really skeptical about mediation. I don't think I've ever met somebody who said, oh, mediation, you're going to solve my problem. What I tend to get is, I don't think this is a process that's going to work. But if they know you're a veteran, then there's that trust. I also find a lot of the time, whether somebody tells you or not, you just pick up. You just know they're a veteran, just the way they carry themselves and the way they are. But also, in the final bit then for me, from Harvey's point, is when I was in the military and being a military mediator, we all used to go to mediation in our civilian clothes to maintain, get rid of the power imbalance. But I, as a major, I mediated between a 3-star and a corporal. Now the corporal knew that the guy was a 3-star. I certainly knew he was a 3-star. He knew I was a major, but we managed to do it all perfectly well, and we got to an agreement. I managed the power imbalance. So we found pitching up in your civilian clothing was a bit ridiculous, because you're using a military email system to set up the mediation, so they know you're a major in the first place, the mediator. I knew they were a corporal. I knew he was a 3-star, and you play the game as a mediator and just do it neutrally. I wouldn't say it wasn't difficult, but hey, that's what you get paid the bucks for. But I think with veterans, you do have to be aware of your bias, especially when there's one veteran and a non-veteran. But once you're aware that you're going to have that bias, then you just control it like every other human being does with all of our biases, and just make sure that you're neutral and you provide a level playing field.
And what's great about mediation is when you're dealing with somebody's well-being, when it comes to housing, nothing is more of a priority than keeping somebody in their place. So I'm so grateful to have the skills that I learned from mediation to then in turn do it, because and since we started in 2009, we've had over 700 people either get rehoused or where we have saved their housing. And mediation has been a strong part of that. So just wanted to point that out.
Absolutely. Ludmila, do you have any thoughts? And then Harvey, I see you raised your hand again.
Well, I have no comments. However, I would like to say that my first knowledge regarding the mediation I have received from the Ukrainian Academy of Mediation, and civilians were teaching me. And definitely, when I will represent myself, when I will introduce myself, I will definitely say that I'm a veteran, since in the process of my work, there might be something which might violate my civilian's position. And thus, I will terminate the agreement. There might be something of my client, let's say a client might be against a veteran, let's say. However, I believe that we need to respect all the professions independently on whether you're a civilian or a veteran.
Thank you, Harvey, you had something else to add to that.
Yeah, I just want to slightly change the subject and another item that Chris brought up. Chris brought up that in England, that veterans are looked down upon. And this was a shock to me, but it shouldn't be a shock to me because if I remember correctly, the Winston Churchill was voted out of office as soon as the war ended. And so I can see that point. The point I want to make is whether or not how a veteran is treated when they come back is very important. For a Vietnam veteran, we were shunned. I was spit upon. Others were spit upon. We were discriminated against in every single way. The society in America then couldn't distinguish between the war, which was unpopular, and the warriors. Since then, the public has been able to distinguish between the war and the warriors. We haven't had a popular war since then. We really haven't had a popular war since World War II, but we haven't had a popular war since then. But warriors, veterans, are not discriminated against the way they were when I left the military and went back into society. I hid the fact that I was a veteran for 20, 30 years. I've changed, but I really hid it. And I'm wondering if how one is treated as when they come back as a veteran is one of the root causes of distinct problems that veterans might have, that we see them in a mediation context with disputes that might not be as the same or as intense as if civilians had the same conflict. I'm wondering.
There is a body of research out there, Harvey, but before I dive into that, I'll let Steve
A
respond.
straight line for you, Jennifer.
Yeah, I just want to say is whether I was dealing with Vietnam veterans that were looked down upon as they came in, or if I think about the returning veterans from Iraq and Afghanistan that were put up on a pedestal, they were still separated. They were different. They were outside the realm of normal. And so the treatment was different than a regular civilian gets. Whether it's good or bad, it's still separate. And I think that needs to change.
Well, Steve, to your point, yes, separation from the military, at least in our country and our experience, has proven to be one of the most difficult aspects of the military life cycle that can lead to some of the most adjustment issues. But to Harvey's point, there is a body of research that shows veterans who come home and are face a smoother integration process and continue to feel as though they belong, whether it's to their unit or community, do integrate more smoothly and have fewer issues in and around PTSD, suicidality, and the like. So there is much to be said about the sense of welcome home and belonging and, the reception of veterans within the broader community. But on that note, just watching our time, I want to check in with Vladislav, see if you have any takeaways or additions to the conversation. And then I think for time's sake, we'll wrap it up. I think this is a great note to leave off on. Vladislav.
Дякую.
Thank you.
Насправді, нам доведеться повертатись
Actually, we will have to get back to the civil society, us, the veterans, and we will have to build the bridges. And you know what? The veterans were the ones who became the veterans from the time of the Crimean occupation, when Russia started the hybrid war 10 years ago. And the veterans were exactly the ones who were getting us together. You know what? when the neighboring building was hit by a drone, you know who first came to help? The veteran. And you know what, if someone is hit on a street, if someone gets into the car accident, you know who reacts first? Of course, the veteran. And the veterans will always be the ones who will respond first. A lot of people say that you don't have to separate them from the society. You have to make them part of the society. Yes, indeed, that's true. However, if we support the veterans, it will motivate them to serve their society, their nation, and the humanity in general.
Absolutely. Did anybody want to respond to Vladislav before I wrap us up?
I think he said it perfectly.
I think he said it perfectly is right. Vladislav, yes, thank you. And this is the perfect place to end, not because this is a conversation that has an end, but because it is an ongoing conversation we're going to continue to have here in the US, there in Ukraine, over in the UK, issues around veteran reintegration and acceptance in the broader community and the culture surrounding that approach is something that is dynamic and ongoing. And it's imperative that we continue to integrate mediation into that conversation to promote better outcomes for our veterans and our military families. So, with that, I want to thank our esteemed panelists for joining us today, taking the time to share your stories, a little bit of inspiration. Again, this conversation is far from over, so I'll remind everybody, please add your networking information in the chat and the Padlet. Make sure to save that chat for yourself. If you want more information around any of the nonprofit organizations that have been discussed, I know I will be providing a link for Homefront Strong. I'm sure Chris will provide a link for his mediation services, and Vladislav, and so forth and so on, in the chat so we can all connect. With that, a thank you again to the Ukrainian Academy of Mediation for inviting us. It has been an honor and a pleasure, and I will hand it back to you.
Щиро дякую. Дуже така тепла.
Thank you so very much. It is a very warm conversation on very important and deep notions. Thank you so very much for the experience that you shared with us. Of course, you have a very diverse experience. And of course, here in Ukraine, where the war is ongoing,
Більш таке, знаєте, поважливе ставлення, принаймні
I
я
hope
всі, з ким я спілкуюся і знаю,
we will have more respectful treatment of those who are protecting us, our houses, and our children. And in my turn, I would like to say that we are ready to support the veterans. We understand that on one hand, we understand the value and the contribution of them in our everyday life. And on the other hand, we are also a part of this losses, pain, and sometimes through our own losses, pain, and challenges that we go through, sometimes we do not have the resources to see and hear that there is a veteran around us who really needs our support. And that's what the mediation can do. The mediation might give us an opportunity to listen to each other, to hear each other, to support each other. And that's exactly what we are doing in our Academy of Mediation. We are promoting a model called Two Wings. That's about a model of co-mediation. In fact, it's not only about the veterans. It's about a diverse experience of living through the war. We have talked a lot today about the trust. Yes, indeed. The mediation is based on trust. And if I don't feel that a mediator is capable of understanding me, that's going to be additional hurdle for me to join the mediation process. That is why we are trying to create a co-mediation model. This is when co-mediators have different life experience and different war experience. This might be veterans experience, this might be combat experience, or IDP experience, or an experience of immigration. It might be also an experience when there are losses of the close ones. This might be an experience of the housing ruination. However, it's definite that a prerequisite of living through the war will be the fact that one of the co-mediators who are trying to help me will be trusted. And I hope that at least one of them will understand me and my experience. That is why we are trying to develop this co-mediation model. And this is just the Ukrainian reality that pushes us to do so, and we will, of course, share this experience with you. One other thing that I want to highlight is as follows. I'm really thankful for what Vladislav has just said. We have to remember about the trust. Sometimes it is easier for me to address a veteran because a veteran will understand me better. Sometimes I can just keep silent, sitting next to the veteran, and the veteran will understand me. That is why our information portal called Mediation Help, we have done a special filter. So I would like to highlight that the veterans, the notaries, the interpreters might get registered here at our portal. And here is a separate filter which allows you to find a specialist. And this filter will tell you whether the specialist is a veteran or not. And it will allow me, for example, to find a former serviceman for me to find a solution to my problem easier. So I would like to highlight this resource. Please get registered and use this resource for finding your fellow co-mediator. And this will help you to cover different life situations.
Thank you for this panel. I would like to give floor to Serge. He is a veteran, and maybe he would like to add something to this. Oleg, if you may. Thank you very much. I would like to share my experience. I'm not a mediator, but everything we were discussing today during the whole forum, in my community, I do it. I try to combine and join and make peace and to bring this into peace. And as it was said earlier, veterans are on the way to help because they know how painful this, because they experience this. They should not be separated. And like a child can approach you and they can say thank you for this peaceful. Sometimes a child just born and I'm born on the east, so I hear nasty things like if the east were not showing off the war had already been over. So if the East were not showing up, the war would end, but there might also be no Ukraine. And I was talking with one of the movements, and every Saturday we join and commemorate the memory of those who died. And there were not a single weekend where we have not met. We are adults, and adults should understand what's going on. And they ask, what are you doing here every Saturday? What are you doing here? And they tell that you are alive, but my son who died at 26 and he says that he was going to war. And I don't know. Interpreter speaking, I cannot hear him properly. At the start of full-scale invasion, it was painful for everyone.
Польський бренд, він створений з хлопців та дівчат, хлопців та дівчат з інвалідністю, які не
There are a lot of girls and boys with disability who cannot go to war, but we do it through music and culture. It helps us support.
Як волонтер можу сказати, дуже дивні речі відбуваються в Україні, але навіть волонтерську допомогу багато волонтерських організацій.
We have a lot of volunteer organizations who think that we don't need volunteer assistance in the west of Ukraine because there is no war there. Maybe there is no active war, but there are veterans with disabilities who get treatment here. And we lack support. And we need to emphasize that we need to join and unite together. Interpreter speaking, connection is bad. We keep losing you from time to time. We heard you about the context where the Western regions there are a lot of girls and boys who are restoring after war, and you meet every Saturday, and the effort you make to join people, to unite them through music, and here I can confirm that those things that you do through music, they are valuable, and tomorrow we will hear it together because Serge created exercise for children related to mediation, and he created a song about mediation. And thank you for what you are doing, using music to unite people, in communities. Thank you. Lisa, thank you. All this forum, I have already told you, it not only resonates for me, it is also common to me. I can confirm that until this forum, I didn't know what mediation is. Not a little bit, not even one word. I didn't know what it is. But after talking to you, to Olga, I understood that this is a familiar story for me, which I would like to put myself into, and I would like to make you feel better. And this song dedicated to mediations that we will have tomorrow, if you remember, I'm writing it not to show off or to show that I can, but so that you can have a tool through which you can also promote mediation. This is not something foreign, it is that everyone can become mediator without having a basic training by just trying to unite with one another to settle peace, but also like to answer a question that was asked to me outside of former forum. If there are a lot of mediators, was the war doesn't stop. And I think that mediation is agreement, and we can make agreement only with those who want to make agreement. If Ukraine wants to agree and wanted to agree, but as a party doesn't want to agree, no matter how many mediators we have, and no matter how we put ourselves in it, it will not work. Maybe I'm wrong, but this is my personal experience. Thank you, Louisa. Sorry that I interrupted your story. We are grateful to you that you texted us that it draw your attention and this magic, and everyone can hear this tomorrow what we managed to do. But when we don't have energy, we switch on search music and we get charged. Thank you. Yana, I see your hand. Please switch on microphone. Yana is a veteran. And she's a military, not a veteran. I'm already lost, but I remember that Yana was at the training at this moment when the full-scale invasion started on the 21st of February. We were supposed to have a training module. It was Thursday. We were all lost, but we still met by Zoom, those who could, and even just to support each other. And Yana joined and said, unfortunately, we have invasion, and Yana said, thank you, and thank you very much. Thank you. You are still finding time for mediation, and you took another train. Thank you, Louisa. I would like to thank everyone. I'm already veteran. I have already demobilized due to the state of health, but I'm grateful that you remember if every man and woman who defends our country, and as a front line, we are there because you're waiting for us here. And thank you for everyone you are doing for us, for nets, for mediation, for child paintings. Thank you. And I would like to share. Me as mediator, I have performed mediation for minors in the active war site, and it is in Drushkivka. It is close to the front line, and mediation exists there, and I'm lucky to be trained in Ukrainian Academy of Mediation. And I was already in occupation when the training took place. Thank you for all your support. Thank you very much. And thank you, everyone who supports Ukraine. Thank you for everything.
Дякую, Яна. Дякую щиро. І насправді
Thank you. And indeed, we have a whole team of mediators who are veterans, and we value each and every one of you. This is amazing how we are inspired by you and inspired by your achievements and inspired by how you keep implementing this information, even about mediation. Somebody uses skills, somebody is ready to do mediation, and we sincerely appreciate every veteran. And thank you from the bottom of the heart for the whole team. And this is just a little thing that we can do to thank you for what you are doing, that we exist, Ukraine exists, and we can join online for the forum to exchange experience and to support one another. Thank you very much.
колеги, сьогодні
Dear colleagues,
черговий день
this is
вчорашнього
yet
дня.
the next
На сьогодні
day
вже
that
немає
has
панелів.
ended. We don't have any more
Будемо
panels anymore.
розводитися
So let's go to have some rest. We still have 2 days to go.
насичений день, як я
Tomorrow
вже
we
казала, це
have
все
a
буде про
saturated
дітей,
day,
для
everything
дітей,
about
для
children,
молоді.
for children, for
І в
youth.
кінці дня
And in the
за
end,
підтримки Лорі Лейден ми зможемо
with
дещо
the support from Lottie
відновитися і
Lade,
увільнитися,
could restore a
подбати про
little
себе
bit,
теж.
slow
Отже,
down and
тиждень був такий
take care of
потужний,
ourselves
насичений,
because it
було
was
дуже інформації
extensive and
багато.
intense
Насправді в нас деякі дні,
week.
ми просто
And
так
some
переглядаємо
days
трансляцію,
we're
дивимося
just
8-10
watching
годин.
for 11 or
Але
12
ми щось
hours the
втомлюємось,
broadcast,
бо
but
запустити.
some of
Просто
it could
хотілося і
have
те
been lost.
підсвітити, і те
But we
підсвітити, і
wanted to
врешті-решт
highlight this and that.
така насичена програма,
And
тому в
this
п'ятницю ми
training
подбаємо
on
завтра
Friday,
ввечері
we
про
will
те, щоб
try to do on
трішечки так
Friday evening
видихнути.
so
І
that you can
ще хотів
breathe
сказати,
out.
в суботу
And we
приймемо
will do
нормальну
it also neuro painting
приєднуйтесь, будь
on
ласка,
Saturday,
завтра
so
зранку у нас
please
будуть
join.
панелі.
Tomorrow we are
Дуже
going
брати
to
участь
have
колеги, сімейні
colleagues
медіатори,
from
які саме
family
приділяють
mediators
увагу тому, щоб діти
who
були почутими, голос
make
дитини,
sure children are heard
залучення дітей в
and
медіацію.
child
І Ліза Паркінсон, і
involved
буде
mediation
Марія
and
Олівєєра,
the
будуть люди
Lisa
будуть
Parkinson,
різні класні
Oliveira,
спікери, і Лариса Греченка з
and
України.
Larissa Grechenko
Буде
from
багато про
Ukraine. We
це.
will be talking
Потім в
about
нас
it.
планується,
Then we plan to
вирішили,
have.
деякі ще такі речі спонтанно в нас відбуваються.
We
Завтра
have it
закінчимо
spontaneously. We will
зустрічами.
do
Хочемо
30 minutes
таке, знаєте,
between
показати
meetings.
за лаштунки
We
форуму.
would like to
10-го показати
show
нашу команду
outside
волонтерів, які
of
долучаться.
the forum, like
Просто
volunteers and team who joined.
побачити, навіть
So
тих
just
там наших
you can
перекладачів,
see even
які
our
забезпечують
interpreters
вже
who
протягом
provide
майже
us
тижня роботу,
interpreting
яких
for
ні в
over
тому
a week now, who haven't
який так само
seen, and
допомагає,
our
щоб
tech
не було
support,
таких якихось
so
технічних
that there would be
негараздів.
no
Щось
technical
негативне трапляється,
issues.
але ми знаємо, що до
And
цього можна
we know
ставитися
that
з
things
розумінням. А завтра
happen.
трішечки
So
спробуємо познайомитися.
we
Далі
will
буде
try to
спеціальна
get to know
подія
each other. Then there will be a
від
special event
молодіжної активістки
from
з Литви,
the
яка
youth
поділиться
activist
інструментами
from
впливу-впливання
Lithuania
для
who will
дітей-підлітків. Якщо у вас запрошені
share
є
tools
підлітки,
for
молодь,
teenagers if you
запрошуйте
have
діток,
youth.
хай з вами розділяють цей медіаційний простір.
So invite them so that they
Після
can
цього в нас
share this
запланована
mediation space. After
ну,
that,
настільки всього
we have so
заплановано,
much
в нас
things
запланована класна
planned.
подія про 5
We
суперсил для
have
дітей.
amazing
І
event for 5
долученими до
superpowers.
цього заходу будуть
And
запрошені діти
we
з
will also invite
Бердичева зі
children
школи,
from Berdichev from school
які
there,
розіграють невеличку
who
сценку
will
для
have
дітей,
a
тож
play
теж їх
for children.
залучайте.
So please invite children as well. It would be interesting for
І о
adults
6
too.
вечора в нас буде вручення
And at
визначної
6
переможці,
we
вручення
will
нагород
have We will have providing awards to those who joined the My Ocean of Understanding and Goodness. We will have winners, and there is still ongoing voting. I don't know. Please, you have 16 works where you can choose one that is going to win and would get the prize. After that, we plan to have a presentation of Serge's song, 4 songs indeed, because they're in 2 languages. We would also have we will have the also of the submarine video. She will share her experience. We will announce a new competition, but we will tell you about it tomorrow. And then we will slow down with Lori Layden. Serge, I see your hand. Maybe you could share where we can hear.
Хочу поділитися перше тим, що я ще зокрема не тільки автор пісень і так
I'm
далі.
not only the author and songwriter, I'm also the representative of Reiki Indian School. And today we had a communication with the founder. He is Indian. And tomorrow Reika School would join also Reiki youth and children. Youth who trains in our academies in Ukraine and abroad. Those who are in Kyiv or Kharkiv, we invite you to our office. There will be tea, coffee, you can sit there and it is safe there. And we have a cellar, so we can use it as a shelter. So it is safe even during the alarm and air raid. And on Saturday at 18, we are planning to do for you, for forum, for team. We will have a meditation for peace all over the world. This is a weekly meditation, but we decided that this week, since we coincide with the mediation forum, then it means that it is needed. And we will have meditation with mediation.
Звучить класно, насправді, бо ми постійно в парі йдемо.
Але ми будемо раді бачити абсолютно всіх, хто захоче, десь годинку-півтори, не більше, може навіть і менше, але у вас буде можливість трошки перезарядитися. Я знаю просто по собі особисто, тому що, знаєте, після тижня робочого дуже класно присвятити собі трошки часу і розслабитися. Тому я офіційно всіх запрошую завтра і післязавтра. Я цю всю інформацію скину з вашого дозволу у всіх ваших там чатах, всюди, де можна, і будемо раді вас всіх бачити. Я вам дуже дякую.
Дякую, Серж. І якщо ви, можливо, скинете посилання, де пісню шукати.
А пісня наша буде розміщена завтра. Я от тільки не знаю, як краще зробити в 10 ранку її опублікувати або в 18 годині, але вона буде опублікована на всіх наших офіційних сторінках в Тіктокі, Ютубі, на сторінках Польський бенд, і Академія медіації так само може її опубліковувати, коли вам буде зручно і коли ви маєте то доцільним зробити. А офіційна презентація, ми її зробимо так, як і задумували. Я думаю, що у нас все вийде. Я, якщо чесно, дуже-дуже хвилююся, і чим ближче час презентації, воно, знаєте, найбільше хвилюєшся, тому що насправді за плечима у польський бенд більше 100 пісень, але вони всі військові, вони всі на військову тематику. А отака робота з точки зору медіації, а тим більше руханки для дітей, це було супер крутезним експірієнсом, котрий для нас є цінним. Тому я вам дуже дякую. Ви особисто, ваш форум привніс в нашу творчість щось своє. Ви її трошки трансформували, ви її не перевернули, ви її не поламали, ви її розширили. Такого до вас ніхто не робив, і такого ми не думали, що таке буде колись. Тобто ми задумувались, і наш мейнстрім – це війна і зосередження на проблематиці війни. А тут медіація, тут діти, тут руханки. І я вам насправді дуже-дуже вдячний. Ви маєте просто невичерпну енергію, і це є супер круто.
Дякую, Серж. Це про те, про що говорили протягом цього тижня. Ми настільки різні, і це настільки цікаво, якщо тільки ми знайдемо час приділити увагу одне одному, почути одне одного, відкритими бути одне до одного. І тоді можуть ось народжуватися якісь нетипові, неочікувані трансформації. Тож, ви можете завтра абсолютно спокійно о 10-й розмістити, бо я вже відчуваю, що, можливо, не всі навіть вночі будуть нормально спати, бо вже тригер цікавості настільки піднятий. Отже, якщо воно навіть буде розміщено раніше, то що це означає? Ті, хто, можливо, прослухає цю пісню раніше, вже під час її трансляції на форумі вже зможуть підспівувати. Тож, мені здається, що це гарна ідея. Хтось вже буде знайомий на момент офіційної презентації. На цій позитивній ноті будемо сьогодні завершувати. Ми не можемо, це в нас традиційно, раніше 9-ї вечора, як це? Ми до наступного року доведеться програму просто робити до 9-ї вечора. З вами просто тепло, класно, не хочеться розходитися. Особливо вдячність за всі ваші ось ці лайки, підтримки для всіх спікерів, для учасників, за атмосферу, яка є в нашому чаті. Дякуємо невимовно просто, бо це нам надає сил, дозволяє рухатися далі. І ми теж з нетерпінням чекаємо вже завтрашнього дня.